That's why I don't know why. Item number 1 to 5. Item number 6 to 11. Item number 12 to 19. Item number 20 to 33.
Item number 31. It's a PIL filed by a colleague advocate who is appearing on person, my lord. Now, recently his brother died in a road accident and he's under bereavement. He committed
4 weeks.
Fine.
It's not before.
Maybe, Lordship. Item number 32, Lordship. Lordship, in this case, we will file an additional affidavit, Lordship.
32.
32, Lordship.
3 weeks.
Deeply obliged, Lordship.
May it please your lordship, with due consent of the other side, I beg to mention item number 29 of the daily list, my lord.
29. Yeah.
29. I'm praying for some time to file our affidavit, my lord.
Should we inform the other side?
Yes, my lord.
I'm for the other side.
Arjun. Arjun.
Your Lordship, this matter is a part of a series, Your Lordship. This matter may be tagged along with the series.
This item number 29.
Yes, Your Lordship. WPC 489 of 2022.
Give the numbers.
Yes.
This along with so and so.
Your Lordship.
Highly obliged, my lord.
Yes.
Item number 25 to 39.
It's 25. Item number 25, Lord. This is a matter pertaining to the illegal formation of a committee, Your Lordship, for a Jal Seva mission by keeping the resident of the local Kodamani town under complete darkness, Your Lordship. This is a PIL. Your Lordship, when the committee was formed, the president was elected without informing the public by taking some signatures from the secretly from some common people. And also the president's son was also elected without informing the public as the employee of
What do
the.
you want now?
Yes, Lordship. Now, what we want is a new committee, maybe from according to the rules and regulations that has been
Let
enacted.
the matter comes. Then argue it.
Lordship.
mention है चलिए
Also,
It is only for mentioning.
Beg your lordship indulgence to release the matter on Monday, my lord. This is a matter, my lord, against the judgment of the Central Administrative Tribunal, Guwahati Bank.
Monday.
Monday.
listing of a review petition, my lord. There's an urgency in the matter, my lord.
Review petition.
Review petition.
For
Before, my lord, consider Chief Justice bench of Sumitra Saikia, my lord.
when the bench is going to be formed. Don't know.
My lord.
Whenever the bench formed.
Whenever the bench is formed, my lord, that.
Mr. Sharma, what is this? This matter that we placed in the administrative side.
My
You're
lord,
making a mention
I
of
have,
the
I have,
judicial side.
I have already placed it there. There was no response from that.
Pass the appropriate order in the administrative side. Yes.
Daily list for orders item 1 to 4.
My lord, herein compliance was to be made by payment of arrear wages.
The last occasion you.
My lord, we
showed
said
in the
that-
March 2024 will.
My lord, 60% was paid in February, 40% we were supposed to pay in March, my lord. But then March and my lord, there were plenty of holidays and bank financial closing was there. So fund placement has come up 2nd of April. So today and tomorrow, my lord, the money would be dispersed. So lordship would give me a week's time to file the compliance.
Monday.
My lord, I'll file the compliance file.
Monday.
Give me your.
Item 5.
May I please your lordship? Lordship may be taken up IA number 906. This is for substitution of respondent number 10, 9 and 10.
Yeah. 3163.
906. During pendency of the case, the secretary of the society has expired.
Eleven is expired. They want this, you can't, there's no need to increase legal aid. He was included because he was secretary of them. So there's a fishery system. No, this is really, really against that is right there. Yes, yes. So, then it's,
Who is the new secretary?
Mr. Jintu Borman. Page number 6 and 7, where
yes. Year number 906 of 2024 is preferred on behalf of the finance. The declare 52, the respondent number 11 on account of death of the respondent number 11. Stop. Taking into consideration the contents of the application, we deem it appropriate to allow the same and allow the same. The respondent number 11, Jagdish Burman, seems that we substituted by Shri Jentu Burman, the present secretary of the society, respondent number 10. Amended cost title already filed, taken on record. You have already filed the amended cost title.
Lordship.
Amended cost title you have filed.
Lordship, Lordship.
Amended cost title already filed, be taken on record. List these matters after 2 weeks.
Lordship.
A date may be fixed, Lordship.
2 weeks, बाद में whatever the date.
I have disposed of.
I disposed.
Item number 6.
No.
Well, this is application for conduct of delay, my lord.
My lord, I appear for the writ petitioners, here respondents. My lord, since the delay is of approximately more than 4 years, we would like to file an objection, my lord.
553 days.
My lord, in fact, we have made our calculations. It would be of more than 4 years as per
Since
our
they have made
calculation.
An application for modification and that was decided only.
My lord, it was more a subterfuge, I would submit. That interlocutory application in a disposed of writ petition was more a subterfuge. It was for the purpose of getting some kind of a clarification, which on the facts of the case were not even necessary. That is why the matter was delayed, my lord, for that purpose.
Constantly here this matter, the on merits of.
Very well, my lord. In that case, my lord, may kindly date be given, my lord. On merit, I will address my lord.
Will condone the delay and hear the matter on merit.
Very well, very well. Very well.
Notices have been served upon all the respondents.
Understood. All the private respondents, my lord. All the private respondents.
You are appearing for all.
Yes, my lord.
All the private respondents. And who is appearing for the Union of India and State of Assam? 3, you are appearing.
2 and 3.
2 and 3, you are appearing. Union of India. Okay. The matter comes upon for consideration of the IN number so and so with the prayer to condone the delay of 553 days in filing the connecting appeal. Stop. The notices of the IA have already been served upon all the respondents. Mr. So and so is appearing on behalf of the Union of India. Mr. So and so is put in appearance on behalf of the respondent number 2 and 3. And Mr. So and so is appearing on behalf of all the private respondents. Stop. Having heard the learned concept of the parties and after going through the contents of the application, we deem it appropriate to allow the same. The delay in filing the connected appeal is condoned. IA is disposed of. Registry is directed to register the connected appeal and list it before this court for admission on
After due vacation, my lord, any day.
May.
After
Could
the
it be in the, could it be in the first week of May, my lord?
First week of May, any day.
First,
Oh, very good. Labor's Day. Labor's Day.
Item 7.
And court to decide in our favor on Labor's Day.
No,
we have taken step.
Respondent number 1, 12 and 13,
Yes, ma'am, we have taken steps, my lord.
taken steps,
Steps we have taken, ma'am.
but you have not AD card unserved notice. That has not been, they will await for the notices, await return of notices of respondent number 1, 12 and 13 for 3 more weeks.
No, like.
Item 8.
My lords may kindly peruse the last order, my lords. A direction was given to conduct a joint survey in presence of all the concerned parties, my lords. So that has been done. And now
It's completed or not?
measurement has been taken, my lords. Now CPW,
Measurement,
yes, my lord.
last occasion also you have taken the measurement.
No, my lords, there was some dispute that some party was not giving some details, somebody was not cooperating. So the learned court, my lord, on that day, taking consideration on everything, every aspect, directed a de novo verification, a joint measurement exercise, my lord. That has been done, my lord.
So now, in how many days you are finishing this valuation report?
My lord, a week's time is required to prepare the report, my lord. On first, it's the verification was done on 1st of April itself, my lord. On that date, the year of construction were provided. You know, 1 week's time, my lord, I have taken instruction. Within 1 week, valuation report will be submitted, my lord.
Okay, and once of the parties have submitted that a joint verification has already been, has already conducted on 1st of April 2024. And the CPW shall furnish, shall prepare the valuation report within a week,
My lord.
within a week from today. Stop, taking in consideration. Does this matter? You vacation के बात की
My lord, may I pray, my lord, we will let us proceed with the work, my lord. Since measurement has been taken, my lord.
Let
After Bihu, my lord, again it will be delayed, my lord. It's after Bihu, my lord, it will go. My lord.
10th of April.
Obliged, my lord.
Item 9.
May I please, your lordship? Lordship, this case for the restoration, your lordship. Lordship, on last 7/2/2024, lordship.
Why it was dismissed?
Lordship, dismissed for default, lordship, earlier. It is dismissed for default, lordship, earlier. On 7/2/24, your lordship, I am out of the station due to my annual death program of my father, your lordship. That after your lordship and last 30.
Is your explanation for not appearing? In the 3 or 4 occasions,
Lordship,
on 30th of August, 21st of September, then 8/12, and again on 7/2/2024.
lordship.
You are not serious about the matter.
Actually, being a petitioner in person, my name was not shown in this cause list also. And what happened is in this specific date, your lordship, I am already submitted, your lordship, all
What's your
documents.
name?
My name is Deven Saikia. Petitioner number 2,
What
lordship.
is this PIL for?
I am the petitioner number 2 and APA for the Sadharan Jati Vikas Parishad Ahom, lordship.
What is the grievance?
Grievance is that what happened, your lordship, there is one of the notification issued by the government of Assam, your lordship. What happened, this organization represent the general class population of Assam, your lordship. This is the one of the represent organization, Sadharan Jati Vikas Parishad Assam. It is a registered organization. What happened, your lordship? On that notification, your lordship, this is the July, lordship. What happened in medical ground, your lordship? Some reservation newly completed, your lordship.
Yes, madam, what do you want to say?
Lordship, it was absent for 4 days. He has explained the reason, but his name was shown earlier on post list, Lord.
Name was shown there.
Earlier, Lordship. Last occasion not shown, Lord.
Yeah. There were, this erroneous case is filed on behalf of the applicant with the prayer to restore the PIL number 52/2023 to its original number, which was dismissed by this court on 7/2/2024 on account of non-appearance of the applicant. Full stop. The court has noticed that no one has appeared on behalf of the PIL petitioner on 30th of August 2023, 21/9/2023 and 8/12/2023. The net concept for the petitioner, applicant has submitted that as he was not keeping well and under the constant treatment, he failed to appear on the day fixed. Stop. It is also submitted that on 7/2/2024, the name of the applicant who is appearing in person, name of the applicant, who is appearing in person has not been shown in the cause list. Stop. Having heard the learned concept of the applicant and after going through the contents of the application and also after hearing the concept of the respondent state, we deem it appropriate to allow the miscellaneous case number so and so ordered accordingly. The writ petition PIL number 52/2023 be registered to its original number, be restored to its original number and list before this court after 4 weeks.
Specifically, my name also may be shown in the last page.
After 4 weeks, while reflecting the name of petitioner number 2 in the cause list.
Highly obliged.
Item number 10.
Lordship, this IA has been filed for condoning the delay of 158 days in filing the conducted writ appeal. We have already served copies, as directed in the last proposal.
What do you want to say?
I'll be appearing for 3, my lord.
What do you want to say? No objection. The IA comes upon for consideration of the IA is filed on behalf of the applicant with a prayer to condone the delay of 149 days in filing the present appeal.
158 days.
158, 159, 149, we are not sure. Let it check. So and so delay in filing the present appeal. The application is not seriously opposed by the counsel for the respondents. Having heard the learned counsel for the parties and after going through the application, the contents of the application, we deem it appropriate to allow the same. The delay of so and so is condoned.
Obliged.
The registry is directed to register the connected appeal and list it before this court after 4 weeks for admission. Yes.
Item 11.
May it please the lordship. My lord may kindly take up IA 893 of 2024. My lord, this IA is relating to, my lord, an amendment that we are seeking in the address of the respondent number 7 in the cause title of the review petition, my lord. Now, in brief, my lord, what happened, this address which was inserted originally in the writ petition was changed during the course of this review petition. And while we were taking steps on the respondent number 7, we came to realize from the office note, my lord, that the address of the respondent cannot be located, my lord. And therefore, my lord, on the last occasion, your lordship was pleased to allow us to take appropriate steps and file a amendment application. my lord.
Number so and so is filed on behalf of the applicant with a prayer to amend the cause title of the connected review petition. Full stop. Having gone through the contents of the application, we deem it appropriate to allow the same. The applicant is permitted to amend the cause title of the connected review petition as prayed for.
My lord, the address is at a page
As
number.
prayed for.
Yes, my lord. I'm highly obliged. my lord. Deeply obliged.
Item 12.
May it please your lordship. My lord, we had filed, this is a matter relating to conservation of a wetland, which is an international Ramsar site in near Guwahati. My lord, what has happened? On the last occasion, we had filed a miss case flagging two very important issues. In your lordship will turn to page 20 of the miss case. Of the IA. lordship. It's an order of the lordship on 7/12/2003. Sri KP Pathak Standing Council Forest has furnished a compliance report dated 23/11/2023, wherein it is stated that the proposal for approval for revised draft notification for declaration of the eco-sensitive zone of the Deeporbill Wildlife Sanctuary was placed before the cabinet meeting on 16/11/2023. He further submits that the cabinet desires to make some modification and also asks for clarification in the revised draft notification. The same is under process. Accordingly, lists the matter on 18/1/24, by which date if the notification for declaration of eco-sensitive zone of the Deeporbill Wildlife Sanctuary is not issued, the concerned secretary shall file an affidavit stating the reasons as to why the notification has not been issued and the progress made till date. In the meantime, the pollution control and water resource will find their respective affidavits. Then your lordship will come to page 24. In terms, can I read, lordship? Page 24. In terms of the order passed by this court on 7/12/2023, the additional chief secretary to the government of Assam had filed an affidavit. D. Saikia, Learned Advocate General, Assam, has submitted that a draft notification declaring the Deeporbill Wildlife Sanctuary as an eco-sensitive zone has already been prepared, and the same will be placed before the state cabinet for approval within a period of 2 weeks. And after approval from the cabinet, the same shall be forwarded to the central government for approval. Learned Advocate General has submitted that the process may take around 6 weeks' time, listed after 6 weeks. Well, one thing I like to submit that the affidavit filed in pursuance of the order of this court, the forest secretary did not mention anything about the eco-sensitive zone. Only he said that the Honorable Chief Minister Assam wanted a detail to the cabinet regarding the earlier notification of 2009, and he will like to examine it in the cabinet meeting. Then what happened? Suddenly, we get an information in the public domain that on 10th of March 2024, the cabinet takes a decision to denotify the entire wildlife sanctuary. In fact, what has happened on the same day, two decisions were taken particularly on that cabinet decision. One was the Povitara Wildlife Sanctuary, which was also denotified. And on the next day itself, Supreme Court in the Godavarman case, Rohit Chaudhary and activists had moved, and the Supreme Court stayed it on the ground that the wildlife there, here the forest dwellers' rights were to be adjudicated. And the Supreme Court says that the forest dwellers' rights they can coexist with the wildlife. But why are you denotifying it? And denotification after Godavarman Supreme Court's, that famous case, Lordship, they have put a rider that in National Park and Wildlife Sanctuary, when you denotify, you have to also take the approval of the Supreme Court along with the National Board of Wildlife. So my contention is that we had brought two issues before this court. One is that let the cabinet decision be placed, because that day we didn't have the notification, and in a PIL, we can always call for it. The second very important issue which we flagged was that in the Ramsar site, since it was not notified from 2002, the wetland rules in the meantime had come into operation in 2017. And they were supposed to notify it, because once the notification is also done, certain duties were enjoined on under the rules. We could find that in the perimeter, some sort of land filling was going on. Malad, we could get some photographs. And this land filling and earth filling, whatever, where basically the conversion could happen, we never knew. So we also brought this to this notice of this court, that you have not notified it. Now you are taking a decision to withdraw it. So what will be the entire depot will now be destroyed, because
What is the question of withdrawing when they have not even notified it?
Malad, no, it was a notified wildlife sanctuary. Our contention was that on to 10th of March, the cabinet decision, they took a decision to denotify the wildlife. Because the purpose is, because our grievance was the court was already in session of the matter. Because the court had already said, because the eco-sensitive zone have to be notified.
Supreme Court order. Isn't Supreme Court order?
Dipperville was earlier notified as a wildlife sanctuary.
It was notified in the year 2009. There was a series of litigation, which I am coming.
Just a minute,
Yes.
There is a judgment of the division bench.
Yes.
Which had set aside.
Set aside the order of the single judge
And restored the notification of,
2009.
that is, what is that notification?
Malad, that notification, Malad, this is the judgment. This was a judgment passed last year on 24/3/2023. Because there are some fishing communities' rights were affected, sought to be affected, and the courts held that that was not the case.
Yes, Lordship, so far as that earlier notification is concerned of 21st February 2009,
Yeah.
the total area covered is 4.1. And the learned single judge, my Lord Justice Roy was there, Lordship, it was set aside. and in the appeal, it was restored. Now the government in the cabinet decision, I have received very partial instructions that the honorable cabinet by meeting dated 10/3/2024 has taken the decision to cancel the government notification already issued in this regard, as the same was issued without approval of the cabinet in clear violation of the rules of executive business. No formalities was followed. That is number one.
2009 notice.
2009.
Which
So
has
it
been
was
affirmed
void
by
ab
the-
initio.
Which has been affirmed by the division bench.
Division bench. Now we are coming. No, it was not affirmed. Division bench reversed it.
Single judge judgment.
Yes, Lord. It was reversed.
So it is almost affirmed.
Yes, now what was found, so government have to do certain things. Now that final notification for denotification has not been issued. So cabinet has taken a decision. So whatever formalities we have to take, we'll do. That is number one. And so far as Deepar Bill is concerned, it consists not of 4.1 kilometers. It consists of 4.2 kilometers of forest area, 6.8 kilometers of the Water Bodies Act, and 8.4 kilometers under the master plan. So there are three different areas. So what my learned friend is arguing, it is regarding encompassing only 4.1 square kilometer. But we are reviewing it now. And further, the cabinet has taken decision. The honorable cabinet did not accord approval for notification of the eco-sensitive zone of Deepar Bill Wildlife Sanctuary, but directed the Environment and Forest Department to prepare special draft bill in consultation with the District Commissioner Kamrup Metro in the line of Ramsar Convention, and directed the department to place the same before the cabinet after model code of conduct for ensuing election is over. So the exercise is going on now. Further, it may be noted that the existing master plan of Guwahati Metropolitan Development Authority Deepar Bill has been kept under eco-friendly zone. A note from the CO has also been given to me. So I would like to file a short affidavit because the decision has been taken, because whatever notification was issued initially, no formalities was followed. The procedure is there. And rightly, the learned single judge set aside it also, but in the division bench, it was reversed. But if we have to go do certain things.
Rightly, you have challenged that order of the learned single judge.
Absolutely,
before the
Lordship.
division bench, and
Now
you are saying that rightly.
no,
the
if
learned single
required,
judge, why
we'll
you
have to
challenged
file a
that?
review application. It is not that that is the end of the road. If required, we have to go to Supreme Court or we have to come before this honorable court also. When the department filed that appeal, Lordship, the certain things may not be there. What exactly?
Mr. Saikia, is there some earth filling work going on in Deepar Bill?
That information I do not have right now, but I am told, not very formally, Lordship, that some national highway work is going on, not here, somewhere else. In fact, we got order from the honorable NGT also, that when the second track of the railways was constructed, we stopped it. We are in the mode of protecting Deepar Bill, Lordship. But it has to be done in the proper manner. Now, lot of things has already been, but we want this honorable court support also, because lot of people will come again. So there should not be any flaw in our exercise.
No, here, if I may like to submit one point, Malad, the government of Assam has to be very clear on one point. A total 360 degrees being taken by the state government. Why? Because the appeal was filed by the government of Assam to protect the wildlife sanctuary. And accordingly, the judgment of the learned single judge was set aside and the wildlife sanctuary part was upheld. It is at that point of time, the cabinet now purportedly takes a decision to withdraw. That part has to be made clear.
No,
Well, as regards the sincerity of the Assam government, they have already given in their affidavit that they will protect. If they protect, then why are they withdrawing the wildlife sanctuary? That is the most important thing. And in fact, Lordship will find that this Deepar Bill case has some similarity, in fact, with the Povitora's case of the Supreme Court. The Supreme Court was also delving there with the rights forest dwellers, and here the rights of the fishermen. Usually the government of Assam has taken a very correct decision in the single bench and the division bench. In fact, my learned colleague, he also appeared in these two cases. He had made a submission that the rights are not there as the fishery, because when the wildlife sanctuary part comes in, The question of fishing rights cannot be given. At most, the permit can be given in terms of two Supreme Court judgments. So our anxiety is that you don't demarcate the Deepor Bill Ramsar site, you don't notify the wetland rules, and now if earth filling is going on also, then virtually the entire Deepor Bill will be, and these photographs, we could get it from the persons who are the petitioners, they stay nearby. They are not persons from outside. They say that earth filling is going on because there is no demarcation. Well, this is too serious a matter. Because
Mr. Saikia, what is the matter? Could you
That
please
is
tell
why
us?
Lordship, let the matter come up on Friday. In the meantime, I'll get complete instruction, including the cabinet deliberations. The cabinet deliberation also I'll have to go through.
Because
Because his proceeding has gone ahead with the idea to protect Deepor Bill.
In fact, we requested the Honorable, there was just direction of the previous learned Chief Justice Lordship that we have to do certain 8 point or 10 points were given. We are already on job.
And
we are trying to do it, all these things came up.
my lord, the directions which were passed in consonance with the government's view, my lord, one of the direction was, my lord,
Let the matter be taken up on Friday, Lordship. I'll
one of the
complete
direction
instruction
was
whether
that the encroachment should not be done of the Deepor Bill.
Take your own time. In the meantime, don't issue any denotification.
Yes. Well, that protection helps.
that we cannot do till now because of this, all this.
But maybe we are passing now.
Let that order be passed on Friday, Lordship.
No, my lord.
Let us file, let us get the opportunity to file an affidavit. No, Lordship, one thing, if Lordship is, no, I have received the instructions, kindly give me 1 day's time to file the affidavit, then Lordship may pass day after tomorrow.
What is the point? Friday I will pass this order that don't need denotify it, and in the meantime, if tomorrow or today you issue a notification of that.
I have received the instructions, Lordship, last evening. This is the 2nd of February, April's instruction. Let me file the affidavit by tomorrow 10:30. They let the matter be taken up day after tomorrow, Lordship.
Well, in the Supreme Court
Because
also, affidavit was.
ultimately, Lordship, the thing is that it is the media game which plays and which creates problem. The media, and I understand, Lordship.
At least so far as regarding media is concerned, I am not at all.
No, Lordship is not, the government is concerned. Wrong information is given, spread.
Maybe. Let us see. We'll hear you.
Let our record be clear, then Lordship may pass whatever order, that is not our domain.
Yeah. I submitted that, though the state cabinet has decided to re-notify Deepor Bill Wildlife Sanctuary. However, the formal notification has not been issued till date. So he prays, today's time to file response on behalf of the state government. Time date for his granted, list on so and so. In the meantime, don't issue such any denotification.
Will not issue, Lordship. Till day after tomorrow, I am giving as but that order may not be passed. I give.
Will not pass any order.
Yes,
Will
Lord.
not pass any
Yes,
order.
Lordship. Nothing will happen
on Friday.
till Lordship takes up the matter
Friday,
on
Friday.
Friday.
But on the encroachment part also, they will.
We'll get that on that.
Yes. Obliged.
The affidavit is on clarify whether any earth filling work is going on within the Deepor Bill area. Copy of this order will furnished in Mr. P9, that is carried.
Item 13.
This IA is only for a limited purpose of early hearing of the writ appeal, my lords. The matter pertains to MBBS admissions and the MBBS, my lord, from
Argue it out.
next year.
Argue it.
I'm ready, my lord. So the Advocate General is appearing otherwise.
Can it be after the Bihu vacation, sir? Any day after 19th on a hearing?
In respect of admissions in the MBBS boards,
No, my lord, for the session 23-24, they, my lord, appeared.
there,
They appeared in 2023, my lord.
It's
23.
23,
Yes,
24,
my
my
lord,
lord,
not
and my lords, my claim was rejected by the learned single judge.
The
Now, my
IA
lord, my only claim is for next year.
number so and so referred on behalf of the appellants with them. Therefore, early listing of the writ appeal number 379/2023 is considered and disposed of. Plus this matter be vacation ke baad mein for admission on so and so.
No, the matter is otherwise for hearing, Manoj. It's in the hearing category. Hearing.
In the appropriate category on so and so.
Date may be fixed. Obliged. Thank you. Obliged.
Item 14.
May I please, Your Lordship? My lord, we delay condemnation application, my lord, 166 days delay, my lord.
First time it is listed,
First time listed, my lord.
issue notice of the IE number so and so, returnable. Registered AD. You are appealing
Yes, ma'am.
for all
All.
the respondents.
All
Yes,
responsible.
All the respondents, yes, what do you want to say?
No, ma'am, I have no objection regarding delay.
The IE is preferred on behalf of the applicant. The present IE is, the IE number so and so is preferred on behalf of the applicant with the prayer to confirm the delay of 160 days, 66 days in filing the connected appeal. Now, the counsel appearing for the respondent, Mr. So and so has no objection if the delay is condoned. Hence, the IE number so and so is allowed, the delay of so and so days is condoned. The connected appeal be registered and list before this court for admission. So and so date after due vacation.
Obliged.
Obliged.
Item 15.
15, my lord, I'm appealing for the state, my lord. There's a delay of 173 days.
First time it is this.
First time, my lord.
Should notice, returnable so and so registered. AD.
Obliged, Lordship.
Item 16.
May I please, Your Lordship? Lordship, we have taken step what Dusty and the register post, Lordship.
You've taken already step taken.
Lordship,
You are
I'm
very-
appearing on behalf of respondent number 123, Lordship. 123, Lordship, IDBI Bank.
So you are appearing.
Yeah, appearing.
Okay. Mr. So and so put in appearance on behalf of the respondent number 1, 2, and 3. The notices upon the respondent number 4 has already been served. And Mr. So and so is appearing on behalf of the respondent number 4. Service is therefore complete. List this matter for admission. Due vacation. Third week of, fourth week of April.
Lordship, in the meantime, we will file our affidavit.
You may file
Yes, otherwise, Lordship, they have a statutory remedy. Lordship, we have already invoked 13.
Section 17.
Yes, Lordship.
Here,
Till that interim order pass earlier shall continue.
interim is also there.
Lordship,
No coercive action shall be taken.
that's my Lordship.
Till next date, interim order, if any, to continue till next day.
Must oblige.
Lordship.
Item 17 for admission.
May I please, Your Lordship? Lordship, kindly pass over the matter for the date.
Adjourn.
Authorization.
Item 18.
May it please your lordship. The appellant's petitioners all are cultivators, lordship. And they are the landholders of the land in question now. It's land about, all the lands of the appellant's petitioners are almost in a continuous place, contiguously located. It's a huge area of land. But suddenly they've notified, they've noticed that in 2020, they've been cultivating on this land. Some people are, or PW department, some are working over there. Being surprised at why these people are working, they went on an inquiry, they found that, they were informed that on 7/11/2015, the land has been declared as a government khas land, it's a government land. It was a private land owned by us, all settlement holders. And that was also, they were more surprised that they said, all the appellant petitioners, they have issued relinquishment deeds against these lands. They themselves have done it, that's what you're doing. Now,
So is appealing for the respondent?
I am for two lordship.
What?
I am for higher education department, Assamar two lordship.
Who is appealing for the other respondent? You filed your response.
That is PWD.
Yeah.
PWD. PWD.
state government is the most
What
important.
are the
respondent.
official respondents?
Lordship.
Yes.
Yeah, I am for response. PWD. I am for two lordship. And otherwise lordship, paragraph 24 of the Honorable Single Judge's order is 112.
You filed your response or there is no requirement of filing any response?
We need to take it back. We need to take it back.
You need some time.
Let them file affidavit, Lordship. They have not filed affidavit in the matter, Lordship. In our matter.
Third learned concept for the
Some protection, Lordship, intent protection will be given to us.
material available on the court. Stop. Is the case of the appellant that it is the case of the appellant that they never executed any relinquished deed which has been relied by the learned single judge. It is also the case of the appellants that the relinquished deed produced on behalf of the state is forced by. It is submitted that the learned single judge has not appreciated the case of the petitioner in right, case of the appellant in right perspective. Stop. Issue notice, Mr. So-and-so put in appearance on behalf of the respondents. They need some time to file reply to counter to the writ appeal, time period for is granted. List on so and so. In the meantime, status quo as is existing, this shall be maintained till next page.
Deep operation.
Item 19.
The respondent Bharat Petroleum Corporation Limited issued a notice.
Another bank. One of us,
Oh, can it be day after tomorrow, my lord?
when we are not hearing the matter, how can we fix the date? In the administrative side.
Public.
Item 20.
May it please the Lordship. My lord, I committed a mistake, my lord.
You?
The appellant committed a mistake, my lord.
Okay.
What
And every
what had
mistake
happened,
has
my
to-
lord?
Every mistake has to pay.
My lord, yes, I'm prepared to pay, but to what extent? That's the issue, my lord.
Okay.
Now, what had happened in this case, my lord? Power Grid Corporation of India through MSTC, wanted to sell some scrap through auction. Now, the agency was MSTC who did the auction, my lord. The scrap material was 1368 metric ton. And my lord, the earnest money was 10% of the proposed bidding amount. Now, what I did, my lord, I bidded 20,001 rupee per metric ton. But by mistake, while participating in the online bidding, my lord, I made it 2,01,000. So thereafter, a work order has been given to me that you may leave the goods by paying us, my lord, 27 crore instead of 2.7 crore. That is the case, my lord. Now, since I did not, carry out the auction, my lord, then what they did, they forfeited my earnest money. Now, my lord, because yes, there was a lapse.
Instead of paying rupees 27 crores, if they have forfeited your earnest money, that's good for you.
No, my lord.
Otherwise,
Actually, my lord, no loss has been caused to the Power Grid Corporation because there was a subsequent auction, and in that, my lord, the whole stock was cleared, my lord. Let them consider my case, my lord. My lord, I'm prepared. Some money was spent in the re-auction. That money can be adjusted. My lord, at 4:30 PM, I gave a mail saying I, by mistake, please come to page 80, my lord. Page 80. On the same day, that was on 21st of February 22. It is to inform you that by mistake, instead of 20,001 per MT, I have quoted 2,01,000 for the lot number 1 against auction number so and so. This is for information and necessary consideration, please.
The bid was opened on the very same.
It's the very same day, and this was within the time, my lord.
Within the time.
Yes. And my lord, this aspect of the matter was not adverted to by the learned single judge, my lord. And my lord, in the resale, in the resale, if your lordship would kindly come to page 100, my lord. This is the document, my lord, to show that resale, it went on to 9:32 PM, my lord, on 14/9/22. Page 100 on top, my lord.
9:32
PM. When the resale took place, though time was notified as 3:30, but in fact, because of the auction process, it went up to 9:30, 9:32 PM. So therefore, they cannot say that 4:30 was too late. So my only humble submission is, my lord, now they have forfeited my earnest money. Now it is to be examined whether they should do it or not. That is single judge has not accepted.
What is the earnest money? What is the amount?
36 lakhs.
And these figures are not written in words.
My lord, actually it is indicated. But actually, when I print to like 20,000, automatically it comes up. I ignore. I did not notice that. I'm not putting any blame on to that extent. In fact, if I quote 1 rupee, then in figure the system automatically regenerates that. Some amount of money was spent in the re-auction. Let that part be deducted.
How the learned single judge is then?
Yes, Lanet Singh at my lord. Space. It starts at page 22, my lord. Please come to page 33.
Internal page?
Para 20. Internal page 13.
Yes.
It was one of the condition in the auction notice that a bidder who had been successful in the auction process had to submit the earnest money deposit within a period of 7 days from the date of sale intimation notice for accepted lot. It was further stipulated that in case of failure to pay the earnest money amount within the stipulated period, an auction process in case of lot for which a deposit of pre-bid EMD amount was a condition precedent, such pre-bid EMD amount would be forfeited. By the impugned sale intimation letter dated 21/2/22, the petitioner was informed that mineral value of the lot for the auction for which he emerged successful was so and so, and he was required to deposit the said amount as per the terms and conditions of the auction notice.
This 2 crore 73 lakhs.
Yes.
The petitioner
No, my
was
lord, 27 crore, my lord,
27 crore.
27 crore, 37,000 and odd. The petitioner has sought relief in the form of refund of the pre-bid earnest money on the ground of equity and bona fide mistake. It is well settled that equity follows the law, and where a mistake might have been avoided by the exercise of ordinary.
Mr. Chaudhary,
My lord,
in this para number 20, the figure is mentioned as 2 crore 73 lakhs 73,300.
actually, it's wrong. Otherwise, I would have lifted that, my lord.
It is there, na?
No, I know,
The
it's
petitioner
to,
was informed that the material value of lot number 1 auction notice for which he has emerged was successful was rupees itna,
Yes.
and he was required to deposit the said amount as per the terms of auction notice.
huh.
The petitioner has sought relief in the form of refund of
Order
pre-bid
this
amount
very much, sir.
on the ground of bona fide mistake. It is well settled that the
If your lordship should kindly come to page 284, my lord. This is the order by which I was allowed, this is the order. Some typographical error, my lord. Page 84, my lord. Please come to that, my lord. Material value 27 crore 37 lakhs 33,368. And my lord, total security is 2 crore 73,000 3,000 lakhs 73,337. And we are required to deposit 10%. That is, my lord, 2 crore 73,000 73 lakhs 73,337.
The scrap material have been lifted now.
Yes. Subsequently, there was an auction and material has been lifted.
What price?
My lord,
Rate
1 lakh 70,000.
1,70,000. 1,70,000
Per metric ton.
per metric ton. And you have quoted the price 2,000 per metric.
20,000
20,000 per metric ton. It was lifted 1 lakh
for 1 lakh 70,000.
per metric ton.
1 metric. So that way, my lord, there is no loss. It's not that, my lord, we have much right over it. It was successful, it was ভুল করছে, it was something like doctrine of proportionality has to be brought in, my lord. We committed a mistake, but for that mistake, whether my entire 36 lakh.
Mr. Chaudhary, what is troubling us,
Yes,
that the in the re-auction, the price was quoted at 1,70,000
73.
and your was of 2 lakh.
yes.
So it's not a case of absolute
No, my lord, what I'm, no,
on
true.
application of minor error,
Yes.
because it was not a scrap.
No, well, I'm a
2,000.
person who is not worth so much. I'm not a person who is worth so much. So I had in mind to the 20,001 rupees. That's why immediately at 4:30, I didn't know what is going to happen.
Regular reader.
Let them consider our case, my lord. Otherwise, my lord, this hard-earned 36 lakhs will go down the drain. Let them deduct some amount of whatever was the expenses for conducting the re-auction and all. To that extent, we are not saying anything. But not that, my lord, our mistake was so much that it entails forfeiture of the entire amount.
It appears to be a rethink on the price rather than a mistake.
Just my lord, actually, one thing I am pointing out, my lord, today, I'm drawing you lordship attention to page 144, my lord.
144.
144, my lord. For their action, my lord, the proposition has supported the financial loss, my lord, to the extent of 4 crores, my lord. Because there is a difference of price, my lord. Here, the price is reported by him and they
No, there was no reserve price, my lord, in the auction. Had there been a reserve price, that would have been a valid argument.
Even my lord, prior to the entering their bid amount in the portal, my lord, the bid amount offered by him, that was confirmed, my lord. On confirmation, my lord, the amount was entered in the portal, my lord.
Later we realized that.
13, 27, 49 hours.
Okay, Mr. Das, can you please tell us how many bids were received apart from the appellant's bid?
Page 30, judgment, that is single. Before me, the bid was for rupees 1,000, my lord. And page 30, my lord. The learned single judge has taken note of that. Page 30. Second sentence after the comma. It is noticed that auction process started with receipt of the first bid of ₹1 at 11:35 hours. The auction process was forward auction in which bidding started with the lowest possible offer bid value and bid was increased gradually. Subsequent to the first bid, 7 more bids were received. The petitioner entered the bidding process as the 9th bidder at so and so hours by quoting a bid value of 2 lakh per metric ton. The bid previous to the petitioner was ₹1,000. Sir, as a prudent businessman, when somebody is bidding 1,000, why should I quote my lord 2 lakh 1,000? So what was in my mind was 20,000. So I was the 9th bidder and I bidded for 20,001. And my lord, my email of 4:30 PM clearly reflects that position. Now, the Power Grid Corporation stand is, we have given you an work order, you pay 10%, 2.73 crore and proceed with the work. If you don't, then your earnest money will be forfeited. That is what they have done. And there was no, my lord, estimated value.
No, that is the correct procedure.
Reserve price.
What they have done is the correct procedure.
Yes.
There is nothing illegal about
No,
what they have done.
No, what they have done is not wrong also. That we are not, that is not our case. We are just seeking some, my lord, sort of a mercy, my lord. Technically, what they have done is right. That we can't say it's wrong. And it will entail, my lord, if I do not, undertake the work, then natural consequences.
And concept for the appellant has submitted that. As a matter of fact, the appellant has committed a mistake by quoting price of rupees 2 lakh one in the grid. Go.
1 per metric ton.
Per metric ton. Though he was inclined to made a offer of rupees 20,001 per metric ton. Stop. And in consent, I submitted that the appellant is ready to bear the cost of re-auction. And for that, the respondents are not justified in forfeiting the earnest money amount, which is around 34 lakhs.
36 lakhs.
36.
34.
34 lakhs. Issue notice. Mr. So-and-so put in appearance on behalf of the all the respondents.
Number 1, 2, 3, my lord, I'm referring, my lord.
You are 1, 2, and 3, and who is for 4?
MSTC.
In original put they appeared, my lord.
We'll have to take notice, man. We'll have to take steps.
1, 2, 3, let notice be issued to the respondent number 4. Returnable on so and so. Date पे 6 weeks के बाद की दोषी.
Item 21.
Item 21, Lordship, a similar matter, Lordship has issued notice and interim stay has been granted. Lordship. Matter relates to the claim of disability pension, Lordship.
That is from the areas from the date.
And arrears part as item number 23. This is, in these cases, we are claiming that they are not entitled at all. In this case, that disability pension was granted simply because at the time of enrollment, that those diseases were not detected. The tribunal held that since the disease was not detected at the time of entry, so it must be attributed, Lordship.
Same order.
Number will say
Yes.
Item 22.
Please. एक minute, list along with the other matter to be.
See, all the info I can link from. That order it is by connected matters are.
Please.
Yes.
Yes, Lordship. This petition has been filed challenging the impugned sale notice dated 21/2/2024, being
The sale has already been conducted.
sale has been conducted, Lordship, but the certificate has been issued. Sale notice was not in compliance with the SURFACE Act, Your Honor, as well as Security Interest Enforcement Rules of 2002. This being a subsequent sale notice, it must be issued under Rule 9(1) of the Security Interest Enforcement Rules, but
Point it out to the debt recovery tribunal.
Lordship,
DRT.
DRT, also. But at present, DRT, the court is not functioning. Your Honor.
Why?
The PO is on leave.
So it has been taken up by the Siliguri bench. Siliguri bench has been taken up.
For the,
Lordship.
when counsel for the petitioner, we, does not want to press this petition. Does not want to press this petition.
Lordship, may I
Counsel for the petitioner. On instructions as submitted, he does not want to press the petition. Our seeks liberty for the petitioner to approach the DRT. Debt recovery tribunal under section 17 of the SURFACE Act 2022. Dismiss with liberty as prayed for.
Item 23.
Lordship, this is 3 years. This matter dated. Here the tribunal granted from the date of discharge, Lordship.
What was the OA number?
Lordship. OA number 33 of 2019, Lordship.
23.
33.
And date.
Order dated 15/3/2023.
No, in the impugned direction of payment with effect from कब से दिया वो? What was the order?
Lordship.
Tribunal has ordered for paying the payment of areas from which date?
With effect from 1/7/1999.
1/7/1999. No, connect with John. Correction, what we have, the correction.
Item 24.
Yes.
Lordship, this matter is about removal from the service on charge of bigamy. And the learned single judge, while deciding my writ petition, in fact, my writ petition was dismissed at the motion stage, observed that bigamy is a misconduct and the removal from service is not shockingly disproportionate. The substantial question of law of which I placed before this honorable court, bigamy is misconduct, there is no doubt. But question is that whether such misconduct is a heinous crime which shall invite the extreme form of punishment like removal or dismissal.
So why not?
Yes, I'm coming. The Rule 26 of the Assam Civil Service Conduct Rule 1964 is about the bigamy, and Rule 26 only restrict a government employee for contracting second marriage during currency of the first marriage. And Rule 26 remains silent about the nature of punishment.
Here is the question of this in the Rule 26 itself. There is the question of giving the punishment itself. If
Punishment-
it's a misconduct.
Misconduct, obviously, I am not.
If the misconduct and misconduct is proved, then the state is in its discretion either impose a minor or major. penalty.
Major, yes. That is the question. I'm coming, Lordship. The state is always at the liberty to impose any punishment. But considering the nature of misconduct, the Rule 26 remains silent about the nature of punishment, and which is
Punishment, show us where is the Rule 26?
Assam Civil Service Conduct Rules.
sorry, it will be Rule 24, Lordship, sorry.
Here from 24.
I may be
Civil
allowed to
Service
read the
Conduct
Rule 24.
Assam Civil Service Conduct Rules.
Page number 423.
Rule 10, the next page 436. This will does not give a punishment will help in the aspect of discipline. This is the next. These only things of the conduct. It's a misconduct. It's a misconduct. We is admitting. It's ruled. Rule 10, 436.
There is a provision for appeal. Have you preferred appeal?
Appeal preferred. Appeal was dismissed, thereafter petition was dismissed. And Lordship,
So, you mean to say that since in Rule 24 conduct rules, no such consequences provided and therefore they can't impose the punishment?
punishment they can impose.
Then
The nature of punishment, I'm coming. The
nature
nat-
of punishment in none of the conduct rules, there's, none of this condition requires any nature of punishment, even gifts. And this also you mean to say that if a person, there is no consequences provided, he can accept the bribe and say, okay, so what's misconduct? You can't remove me from the service since
No.
In the conduct rules, it is not mentioned.
No, Lordship, provision is provided in the Rule 7 of the Service and Discipline Appeal Rule 1965.
Yes.
And which says there are 7 categories of punishment, including the compulsory retirement in case of bigamy.
That is,
Lordship, I am
depends upon the facts and circumstances of the case. You being a member of a disciplined force has violated the Rule 24 conduct rules, then what remains?
I'm relying on office.
Degree is required. You required being a member of the disciplined force, you are required to maintain this.
Absolutely, Lordship, I am not contradicting on this point that, yes, being a member of the disciplined force, I'll have to follow the discipline. But government itself declared by publishing office memorandum, Lordship may peruse my additional affidavit in page number 74.
What office memorandum?
That I have filed an additional affidavit to place the office
Yes,
memorandum
what
in the
is this?
record.
Yeah, read page number.
74. It is an office memorandum. Deals about the,
Permits second marriage.
yes, it is an office memorandum deal about the second marriage, but particularly designed to deal about the second marriage. It is hereby reiterated that as per the provision of Rule 26 of Assam Civil Services Conduct Rule 1965, no government servant who has a wife living shall contract another marriage without first obtaining permission of the government, notwithstanding that such subsequent marriage is permissible under the personal law for the time being applicable to them. No female government servant shall marry any person who has a wife living without first obtaining the permission of the government. In the context of the above provision, the disciplinary authority may initiate departmental proceedings under the provision of the Assam Civil Services Discipline and Appeal Rules 1964 for imposition of major penalty, including compulsory retirement against the government servant found to have violated Rule 26 of the Assam Civil Service Conduct Rule 1965. So it says that there are 7 categories of punishment which anyone, the authority, that is the government, can impose. And this office memorandum says that in case of bigamy, the major punishment like compulsory retirement shall be
Including
imposed.
major penalty, including compulsory retirement. It even says only compulsory
Yes,
retirement.
yes,
is required.
including of any punishment, but what I can understand, Lordship, dismissal, removal, and compulsory punishment, these are the 3 major punishment. This office memorandum says that for that misconduct, the person can be removed, cannot be removed, he can be retired from compulsory retirement. Up to that extent, they can go to impose a punishment like compulsory retirement. As the reading of the, as per my understanding, because it does not say that person shall be removed from the service. There is a limit has been fixed by the government. Up to that extent, a person can be punished, and this limit is the compulsory retirement. Because the office memorandum does not say that including removal or dismissal. And Lordship may take note of that. It is the first line, it is hereby reiterated that as per the provision of Rule 26. That is, this the content of the office memorandum was applicable since the beginning.
Shockingly different.
The London single judge has placed reliance on the Supreme Court judgment.
Yes, yes. I'll submit on that. I'll address the issue also.
Submit on.
In
You have a
the
copy of
learned
that
single
judgment?
judge lordship, I have a copy of the judgment of the Supreme Court. So I'd like to place it. Another judgment is the similar case is decided by the division bench of this honorable court.
How many years of service you had put in?
I joined the service in 1996
Yes.
and terminated and removed from the service in 2023. Lordship, I have something to submit on the Supreme Court decision.
Yes.
Lordship, this Khurshid Ahmed Khan case is decided on the Rule 29(1) of the UP Government Service Conduct Rule. And second thing is that Supreme Court says that when a person is found the guilty of the bigamy, he may be removed from the service, and it is not shockingly disproportionate. But in the decision, what constitutes shockingly disproportionate is remained unexplained. My understanding is that it is true that unless the finding of the disciplinary authority is shockingly disproportionate, any court of law shall not entertain on the decision. But what constitutes shockingly disproportionate, it remains unexplained, and that has been explained by the Honorable Division Bench of this court in the decision I have placed. It says the shockingly disproportionate would depend on the fact of the case. And fact of my case is that I first time I got married in 2013. On 2 occasions, my first wife gave two baby without life. Under such circumstances, I contracted second marriage with the approval and permission of my first wife. Lordship, my educational attainment will also be taken into consideration. 8th standard pass constable.
8th standard?
Pass constable.
So?
No, I'm just highlighting that a person may not be aware about the technicality about the rule on the service rules. But I'm not praying to have any benefit on this observation, because rules is equals to everyone. The issue is that the division bench of this honorable court observed that when a person is removed or dismissed from the service, it not only deprives the person from his livelihood, but also deprives the dependents of the other family members who are dependent on the person, deprive their from livelihood.
Family members, the wife already you are saying that she has not given any birth to any child, so she is alone. And
She is
the
also
second wife here, so you can very well
My
manage.
mother is depending on me. My first wife is depending on me.
Not
my-
for a police constable.
That is
Not a
absolutely
person
true,
of a
Lordship.
disciplinary
Absolutely true.
force. He is violating that.
That is absolutely true. And this, I'm just relying, it is not my submission. I'm just relying on the decision of the division bench of this honorable court that I have placed. I may be allowed to read out it, Lordship.
Yes, read.
I'm reading from the page number 5.
Yes.
It is true that courts, while dealing with the penalty imposed on the delinquent, normally does not interfere with the quantum of punishment unless it shocks the conscience of the court. However, there is no clear criteria laid down in this regard to define as to what shocks the conscience of the court, inasmuch as it would depends on the fact of each case. In the present case, what comes from the record is that writ petitioner has a child from the first marriage who is about 15 years, and if the said penalty is of dismissal is to be upheld, it will cut off the only source of income, not only for him, but also for his first wife, her daughter, and second wife. The writ petitioner appears to be the sole bread earner on whom first wife and his daughter and his second wife appear to be dependent upon. It can be observed from the records that course of the inquiry, the first wife of the petitioner, Srimati Chandana Nath, had made a request to the authority to look after her and her child, who would be about 15 years by now, which clearly shows the sense of dependency on the writ petitioner, which can be legitimately demanded from her husband. Dismissal is most extreme form of punishment which can be imposed upon a government employee, which has the effect of not only cutting the source of income, thus depriving him and his dependents of the means of sustenance. Apart from it, he will not be eligible for re-employment in the public sector. Thus, the civil consequences entails are extreme nature, which in our opinion should not be ordinarily invoked unless misconduct of such nature is that there is no other option. This part is important, Lordship. There is no other option but to impose such a punishment. There can be various other misconducts for which the most severe form of punishment can be imposed. In the present case, in our opinion, though this act of conduct of second marriage can be said to be an act of indiscipline, inasmuch as the contracting a second marriage during the subsistence of the first marriage was in violation of rules, yet it cannot be said that it is one of the most heinous form of misconduct for which he must be necessarily visited with the punishment of dismissal. The records also do not indicate any serious physical violence perpetrated upon the first wife or the daughter of the writ petitioner, or any other act of cruelty. Though there is an allegation that writ petitioner had beaten his wife, first and daughter, the writ petitioner appears to have contracted the second marriage on account of not being happy in the material life with his first wife. Under the circumstances and taking holistic view of the entire circumstances as reflected in the records, this court, without condoning the said misconduct, is of the view that imposing the punishment of dismissal to the writ petitioner would cause serious economic hardship not only to the petitioner himself, but also to his first wife and his daughter, and also to the other woman. The punishment of dismissal imposed on the writ petitioner will deprive the family members of the financial support and also may deprive them in penury. In our opinion, devastation which may be caused, more particularly the financial hardship which may be caused by the penalty imposed to the family member, can be one of the parameters of judging as whether the penalty imposed is disproportionate or shocking. In our view, keeping in mind the misconduct proved, if a lesser penalty could have been also imposed for the same misconduct, the authorities must examine the impact which will have not only to employee concerned, but also to all his family members who are entirely dependent on him before taking the severest and ultimate form of punishment under this rule. Accordingly, for the reason discussed above, we are of the view that dismissal of the writ petitioner from the service in case will amount to disproportionately harsh punishment, and accordingly we upheld the order passed by the learned single judge in setting aside the order of dismissal. Lordship, my case is squarely covered by this decision of the division bench, decision passed by the honorable division bench of this court.
And my submission is that, Lordship, since there is the alternative provision as declared by the government by publishing the office memorandum, so any other punishment, including the compulsory retirement, may be imposed.
Okay, okay. Yes.
My one more submission, Lordship. In term of this office memorandum, let the authority to take decision, because the office
They have
memorandum
already
is,
taken the decision.
Lordship,
They have taken the decision.
but it is in violation of their own declaration which is made in the office memorandum. It is, this
But
office
remains to
memorandum
take-
is published by the personal department, secretary of the personal department, and the decision is taken by the commandant of the,
Nothing, sir. What it says. It
And
simply says it's a heinous crime. Having which itself a gross misconduct on the part of the government surrounding last bearing on the society. That is what they.
no, misconduct, I am not arguing anything, that it is not a misconduct.
Yes.
My submission is that
They are disproportionate. The punishment is disproportionate to the misconduct proved. This is what your
punishment, punishment is up to the authority, misconduct, I'm telling, yes, it is misconduct, but for that misconduct, what kind of punishment shall be imposed?
that is to be.
The office memorandum says the maximum compulsory retirement.
No, it doesn't say this. Including compulsory,
In-
major
not in-
penalties,
yes.
including.
Major penalty, not including removal and dismissal, including compulsory retirement means, Lordship, my understanding may be wrong, whatever.
Your understanding is certainly wrong. It's certainly wrong.
But this office memorandum remains silent about the dismissal and removal. It only includes the word compulsory
Imposition
retirement.
of major penalty, including compulsory retirement.
That is up to the limit of compulsory retirement.
Something else?
My lord, I'm just only letting one recent judgment of the Honorable Supreme. Similar case, my lord, similar, same type of case. Honorable Supreme Court is dismissed. This case also, my lord, they have lost both the court.
That case, his argument was that he sought permission from the state.
But no, he was not, my lord, taken
The
permission.
court confirmed that no such permission was sought.
He has not taken permission, my lord. Here also he has not taken permission.
That is his admitted.
It's admitted in the poem, my lord. DP also it is clearly said, my lord, he has not
Fine.
taken permission. I am deeply.
Declared the judgment today itself.
Lordship.
Item 25.
May I please? Yes, sir. Lordship, this is a matter pertaining to the illegal formation of a committee for the Jal Jeevan Mission by keeping the local public in the complete darkness, Your Lordship, where the Assam government launched an ambitious scheme called Jal Jeevan Mission under the Rupohi revenue circle, where some opportunities were also granted to the public for employment. But therein, Your Lordship, the committee was formed illegally without following the rules and regulations. Moreover, the president was also elected.
The rules and regulations
Yes,
the
Lordship.
formation of the committee,
The page 15, Your Lordship,
1-5.
1-5. 1-5 and the vernacular 27, Your Lordship. Lordship, may kindly turn to page 30, the last part, Ungo, where it has said the Hobapoti aru an Bikhorgobia Hokolu, where the translated portion is in the page 19, the president and the other office bearers shall be elected by the votes of the people. Here has been clearly written in the page number 19.E.
Just the was constituted when?
This was considered on 10/3/2023. This committee.
2023.
Yes, Lord.
Why you have come before this?
Thereafter,
after a
Your
year?
Lordship, representation was made before the deputy commissioner.
Deputy
On
Commissioner can cancel the or revoke the constitution.
no, Lordship, it was just an representation was made to the deputy commissioner and also to the chief executive engineer. At page 56 and 53 are the representation, wherein a reply was.
They have power to revoke this constitution of the committee.
But Lordship, they have made a reply on the page 60.
Yes.
Uh,
With reference to survey, please find and enforce a copy of the complaint survey. For the report of name, competent requested to inquire the matter and take necessary action.
Yeah, direction was being made in this regard.
Yes, what is that?
Malad, may kindly peruse page 15 for a moment, madam.
Page?
15 of the writ petition. This pertains to my lord, speaks about a bylaw, my lord, in respect of a rural water scheme of 1995. It has no connection whatsoever with the present scheme, my lord.
Why?
Because present scheme is a central sponsored scheme, my lord. It's called JJM, Jal Jeevan Mission. Under that scheme, my lord, there are separate notifications to constitute these village water committees, my lord.
What about this constitution of the committee as per that notification?
It says, my lord, the water users committee of the PWSS will be formed or dissolved in a general body meeting with a quorum of at least 50% of the, I can hand over my later other copies also. 3-4 criteria, my lord.
You find your affidavit with.
Most, I'll file, no issue that, my lord. Most importantly, my lord, they have not disclosed, my lord, will kindly see. After the deputy commissioner's intervention, my lord, they themselves on their own constituted a committee. 2 resolutions, one resolution that this will be the committee, second resolution, they will have a bank account. And my lord, that resolution, that meeting, my lord, elected persons of whom, my lord, 7 are the petitioners. Madam, may kindly pay. Yes, madam, may kindly peruse. Page 60.
Yeah, they elected whom?
They themselves, my lord. Now they are before lordship. Page 61 for a moment, my lord.
64.
61, my lord, starts. It is their resolution.
they say they have constituted a body. Page 61 is the minutes of the meeting, my lord. Then this meeting was attended. These are the signatories, page 63. My lord, may kindly turn to page 64, my lord.
Yes.
Page 64 and the mere comparison of the cost title, my lord. Page 64, serial number 2, Ramzan Ali is the petitioner number 1. It is the newly constituted committee by the petitioners, my lord. There is no public interest involved, my lord. Petitioner number 4, serial number 4, my lord, will see. Mohibul Haq, he is petitioner number 3. Petitioner.
When you have already constituted your own committee, where's the question of?
No,
the-
they say that has not been
It was
accepted.
not,
Huh?
They say that has not been accepted. That will not be accepted. They are not authorized to do that, my lord.
the local public has decided this committee and this was not being accepted. That is the reason why we have.
Out of 11 petitioners, my
So
lord, 7
how
are the
this
committee
Public
members.
interest is involved in this.
There is
What
no,
are the public office bearers of that, whatever the committee
Yes,
is
ma'am.
constituted? It's a separate individual cause of action to you. How this public interest is involved in?
page 9, para 9 for a moment. That is their own statement, my lord. Page 9, para 9, my lord. There are 11 petitioners, my lord. Out of 7, out of them, my lord, 7 are elected, my lord, by themselves. Paragraph 9 is the. Paragraph 9 says, my lord, that the petitioners beg to state that on 28/8/2023, the local concerned public decided to form a committee, namely so and so, for proper functioning and obeying all the rules and regulations, but the same is not being accepted by the illegally formed committee. So out of these members, 7 are before your lordship, my lord.
Yes, Lordship, they are not being accepted.
They could have filed a writ petition then, my lord. And my lord, their main.
Sir, Mr. Counsel, this PIL, we have doubt about this maintainability. of the
Exactly,
PIL. If you have a cause of action, you may file a separate
Writ petition.
petition or whatever, not,
Because Lordship,
not as a PIL before the division bench.
this petitioners was not accepted as the member of.
Whatever it may be, that is your individual grievance.
Yeah.
How it's a public interest, how it's a grievance of the public at large.
Exactly.
The local
They are
people,
claiming that they are the committee, you, one group is claiming that you, they are the committee, another group, you are claiming that we are the committee. It's purely a personal dispute or individual dispute, not a case of
Private interest. Only 2 resolutions, my lord, that we had a committee and we will have a bank account.
but the same committee was also formed without informing anybody.
whatever it may be. If you are aggrieved by that, you can challenge that action, but not in the PIL.
Yes.
Okay, learned, after attempting to argue the matter for quite some time, learned counsel for the petitioner has on instructions has submitted that he wants to withdraw the writ petition with liberty to challenge the constitution of the committee. What is the name of that committee?
ব্যবহারকারী পরিচালনা সমিতি।
Water user committee, basically, my lord. English name is water user committee.
Water user committee of
That village, my lord, that village is
Kodamoni town.
Kodamoni town government.
one more come from by filing a writ petition instead of a public interest petition, dismissed with liberty as per it was.
All right.
Item 26.
May it please your lordship. My lord, against the dismissal of a writ appeal of which in wherein similar relief was sought. My lord, now the matter is sub judice It is showing as 10%.
10th of April 2024. Full stop. And in consent for the parties has submitted that the petition be kept pending, awaiting the decision of the Supreme Court on the issue involved. Let's after it.
We are blessed.
Item 27.
May it pleasure your lordship. Lordship, the applicant before your lord, petitioner before your lordship, my lord, is with a my lord prayer, my lord.
Ma'am, you have argued this matter for
Lordship,
many occasions.
lordship.
We are not inclined.
Lordship, but my lord, only my lord 17 lakhs 33,000 was remained, my lord. Already he has paid 14 lakhs 43,000, my lord, 46,000 to the bank authority. And my lord, the value of the land was, my lord, much higher, my lord. They could have waited for some time, my lord. They have sold the land, my lord, for 52 lakhs 40,000, my lord.
Already the land is sold and sales
So-
certificate is issued. What can we do? Now it's a third party rights have already been created. Sorry.
Readily collecting her. So my lord, repeatedly, my lord, he approached the bank, my lord, for with her to only for wait to grant some time to him because his father expired, my lord, in the 2022, my lord, due to his liver cancer, my lord. So he approached the authority, my lord. City river, the bank of the and
What was the due amount was?
Dues amount at the time of closing of the account was 32 lakhs 58,385. I have stated in page number 8, Your Honor. Page number 8 of my reply, Your Honor. And in para number 14, it starts from page number 7 and from page number 8. We have clearly stated in it. And whatever amount they have paid, it is taken into consideration at the time of. And we have
The
annexed the
due-
statement of account.
And the remaining amount, they.
Yes, it is in the custody of the bank, and for that, bank has issued
Surplus
one
amount,
excess amount, yes,
surplus,
yes.
yes.
It is in the bank custody, and already bank has informed them that it is in our custody and they will
This,
be,
the-
it will be repaid to them.
The surplus amount is around
Is around 15 lakhs 67,070.
My lord, we have paid 14 lakhs 46,000, which they are, my lord, clearly, my lord, they are denying that, my lord. But we have given them, my lord, that slip as well as, my lord, some portion of the land of the petitioners, my lord, were acquired by the government, my lord. So that amount, lordship, we have filed in our reply to the affidavit, my lord, and we have annexed that document, at page 152, that amount of rupees 6 lakhs 46,000 has been already, my lord, credited to the loan account of the petitioner, which is now, my lord, closed
These
by
are
the bank.
These
my
are the
lord.
matters we can't go into all these details. If you are aggrieved,
Because
you already approached the
amount-
DRT has dismissed your application. If you are aggrieved, you can very well approach the appellate tribunal. They'll look into all these matters, not this court. While exercising this extraordinary jurisdiction, we are not supposed to.
Lordship.
Yes.
But the amount they are
Whatever it
denying,
may
my
be,
lord, lordship, on that. my lord, lordship.
Only the tribunal that appellate
Lordship,
tribunal can
lordship.
give you the relief or they can consider.
In the meantime, they can take back the amount, surplus amount without prejudice to their rights. You can take back the amount without prejudice to your rights. The
Yes,
surplus
yes, bank will refund it.
Very well, receive your surplus amount without prejudice your rights, whatever it may be.
What I am submitting, my lord, that 46,000, which the petitioners deposited during the pendency of the, my lord, assay, that they are denying, my lord. They are saying that 52 lakhs 40,000, they will deduct the amount
Can
of.
raise this point before the appellate tribunal, they'll consider it.
Lordship,
You can then.
lordship, that some observation, if your lordship, regarding our submission that we have paid 14 lakhs 46,000.
We are not going to record anything.
Lordship,
We are simply
if my
saying
lord, lordship,
you wants to withdraw this petition with liberty to approach the appellate tribunal, that's all.
lordship,
Where you can raise all the available grounds.
lordship, lordship.
After attempting to argue the matter for quite some time, then advancing with the petitioner has submitted on instruction that he does not want to press this. Who seeks liberty from the petitioners to avail to file an appeal before the appellate tribunal constituted under section 18 of the Securitization Act 2022 against the 2002 against the order dated 11/1/2024 passed by the Debt Recovery Tribunal. It stop. Dismiss with liberty as prayed for. However, any appeal is filed by the appellant before the appellate tribunal, the tribunal shall decide the same, appellate tribunal within a period of 2 weeks from today, the appellate tribunal shall consider the same on merits, ignoring the delay in filing the same. Full stop. In the meantime, the appellants, the petitioners are free to receive the surplus amount from the bank without prejudice to their rights. Without prejudice to their available rights.
Deeply.
Item 28.
It gives your lordship. So this PIL was about the state of affairs in the State Consumer Disputes Redressal Commission, my lord. My lord, the other Consumer Commission, my lord.
Yeah.
My lord, the other aspects which prompted us to come before lordships, they have been taken care of. Only aspect which remains, my lord, is the appointment of stenographers. There was an order, my lord, of 18 July 23, my lord. About regular appointments.
Place on record communication, but you this and stenographer coming from food supply. Shall ensure regular selections. Yes.
My lord, we have already, wrote a letter to the president, Assam State Redressal Consumer, Commission, to give us the proposal to how many posts required. They said initially 13 posts is required for the state consumer. But accordingly, we have written to them to give us the feasibility and other things so that we can, my lord, government can.
When you have written this letter?
This is written on 18th September 23.
What is the response?
No, my lord.
Is his party here in this petition? This State Consumer Forum.
My lord, administrative officer, my lord, respondent number 4, my.
Respondent number 4.
My.
Who is appearing for the respondent number 4? Who is appearing for the respondent number 4?
He's a government officer, my.
Oh,
This is
the
a
notice
petition.
have been served upon the respondent number 4.
Notice to better to go on.
Who is appearing for the respondent number 4?
Register, this is the register of the consumer from the notice may go.
Food and civil supply.
Issue तो हुआ है लेकिन सर्व नहीं हुआ. Eight, six, 2000, but there is no, what? What is 8, 6, 2022? Okay. You should not have.
This is the communication I have received, Lordship, kindly.
Respond number 4 पे कुछ steps ही नहीं है. Have you taken steps for service of notice on respond number 4?
My lord, it was on the government advocate, my lord. Or we may be permitted to serve Dusty once again, my lord.
देखिए कौन सा पद लंदन गवर्नमेंट एडवोकेट एम भट्टाचार्य has informed this court that the state has already Mr. R.K. Bora. London government advocate Mr. R.K. Bora has submitted that the state has already requested the State Consumer Forum, Assam State Consumer Redressal Commission to examine the feasibility of permanent absorption of office staff of the ASC However, the CRC white letter dated 18th of September 2023. However, the state is not in receipt of any response from the commission. Stop. The registrar come administrative officer of the commission is respondent number 4. We deem it appropriate to issue notice to the respondent number 4. The state registered daily returnable on so and so.
Deeply, I am deeply.
Item 30.
May I please your lordship? As per our earlier affidavit lordship, Dibrugarh PS has been investigated by the special investigation team lordship, which was constituted on 39/2023. But completion of the investigation should be within 6 months lordship. We need some time to take the absolute instruction. It is 6 months expired on 30/3/2024 lordship. Page 167 of our affidavit lordship.
Yes, last time you sought time to look into the.
My lord, may I please, your lordship? My lord, I have gone through the statutes, my lord, which has not yet been, my lord, come into as a law, my lord. My lord, may I kindly peruse the statute, my lord. It has just been legislated, my lord, as a bill in the assembly, my lord, but although it has been passed out, but the governor assent has not been given, my lord.
That is the process then.
And secondly, my lord, even if we assume, my lord, that there is a law, the cause of action, my lord, which we have averred in our PIL, my lord, is not covered under this statute, my lord. This is a
What you
matter.
have prayed for.
My lord, we have prayed, my lord, may be pleased to find the prayer made is at, my lord, page 31, my lord, seeking a 31 of my PIL petition, my lord. My lord, there is a direction by this honorable court, my lord, for constitution of a one-man judicial inquiry committee.
That has been
My
done.
lord, yes, my lord, by one of the honorable retired judge of our honorable court, my lord. And that inquiry committee has already submitted its report before the government. But my lord, in that report, a detailed, my lord, anomalies and malpractices had been, my lord, incorporated. That in what manner the malpractices had been carried out. My lord, the inquiry commission has also filed an, my lord, affidavit in connection with this PIL before my lord, my lord. And in that affidavit, if my lord may be pleased to peruse just for a moment, my lord.
And in that affidavit also, my lord, the inquiry commissioner said by the government. My lord has held that the serious malpractices has been done while my lord recruiting the 2013 and 14 batches of the my lord Assam Public Service Commission recruiting. Now, my lord, once the inquiry report is pending before the government, my lord, government was sitting silent without doing anything, my lord. Now, when we approach, my
You
lord.
already enacted a law.
No, my lord, this law has been enacted, but it has not yet been, my lord, passed by the governor.
That
And
has been
secondly, my lord,
passed, it is
no, my lord, this law, my lord, with all respect, my lord, what I humbly beg to submit, my lord, this law will run prospectively, my lord. And our issue, which we have raised of the year 2013 and 14, my lord, if my lordship allows me, if my.
Lordship, government is not sitting idle, Lordship. We have already some action has been taken, Lordship. In page 67 of our affidavit, Lordship, we have stated in tabular column, Lordship. And investigation is to complete within 6 months, Lordship. That 6 months has been already expired, Lordship. We need some time to take up to date instruction in this regard. What has taken by the government?
6 months from what?
6 months for completing the investigation, Lordship.
You have already initiated investigation
Yes, Lord.
in respect of these allegations.
Yes, Lord. Already.
What they have done, my lord.
Kindly see page 167, Lordship. My lord, senior assistant on Abdul Qadir.
SIT was constituted and the time was given to SIT for 6 months. 6 months has completed on 30th of March. I spoke to them that they said that 1 week time is required. What is the update status of the SIT that will face in the report?
Well, my lord, after a week, my lord, maybe please to take up.
Nikhil and counsel, Mr. Deena has submitted that the SIT constituted to look into the irregularities committed during the competitive examination has already completed its inquiry.
No, but the term tenure is complete. What is the absolute position that I'll?
Lord, actually,
that
what
I'll,
is-
that I will take. On 30th of
Had completed its term and
up to date position I'll inform.
has completed its terms and is likely to submit a report within few days. He placed some time to produce the report of the inquiry, SIT before this court. SIT before this court. This month,
From the department I got that the SIT will apprise.
From whom you have to bring.
Well, whether they are submitting the report or not, that I don't have.
That is, you then mention it on that. They are not going to submit any report or whatever.
Obliged, my lord, highly obliged.
Item 33 and 34.
Made to your lordship. Also, in respect of item number 33, lordship, it was admitted on 22/12/2023, lordship. My lord, may kindly clear the 22/12/2023 order, lordship.
22/12.
Lordship. And other matters, and
Appearance, it has already been admitted.
lordship. And 34 also admitted, lordship, in on 15/12, lordship.
Lord, he was supposed to take up the matter for disposal, my lord, in this state appeal.
Is informed that the writ appeals have already been admitted. Stop. It is noticed that, it is noticed that these writ appeals have already been admitted. List for hearing. On so and so date, bata do, May mein date koई.
There is some
interim order, if any, to continue till disposal.
There
of
is some urgency in the matter, Miller. So lordships on the last occasion expressed view that this will be taken up as an admission hearing.
Already admitted.
This is a matter pertaining to selection to the post of
For admission, he likha tha, the admission, because the last occasion we have listed it for admission, but it has already been admitted.
Fine.
So we'll, May, whatever that.
May.
May.
Seventh. Apology, Lord.
Interim stay may be continued.
Seventh May now.
Interim-
Interim stay order passed by this court shall remain in currency till final disposal of the writ appeals.
14.
13th May, 13th.
Apology, Lord.
13 minutes, well, fine.
Item 25.
May I please, Your Lordship? As per the last order dated 26/2, the respondents were supposed to complete the instructions.
In case Sharma Senior advocate appearance of DK Magistrate.
The notice regarding the case.
So the issue was whether a particular answer in the sheet was correct or not. It's kind of the university and the examiner has already been, is already there on record matter in the affidavit position filed by us. So the matter can be taken up for hearing matter then. Because
Huh?
the legislative judges,
Argue it out.
he has to show that the answer was correct because legislative judges held that his answer was wrong.
No, he's
And the examiner's point of view that it could not, marks could not be given for that particular answer. It's upheld.
Learned Singhal, the whole
HSC convinces otherwise.
Yes. Because there is no dispute. Paragraph 12.
Yes.
Lordship, in this case, the learned single judge in paragraph 12 has clearly held that Arunachal is on the eastern side.
Arunachal is the eastern state, eastern side.
Internal page 5, running page 24.
Yes.
So my answer is correct. There is no dispute that the state of Assam is bordered by Arunachal Pradesh in north, in the east Nagaland, Arunachal Pradesh and Manipur. The question that was put to, that can be seen from page 20 to internal page 3. What was the question asked?
That London single judge has taken into consideration this fact. Therefore, the decision of constitutional setter to treat the Manipur to be the correct answer as the option of out of option so and so cannot be said to be glaring defect, and this court exercise of its power judicial cannot replace such decision. What's wrong in that? This is also touching major portion.
Logic means look at the question once for the
Yes.
page 22.
Read.
Page 22, internal page 3.
Yes.
Point number 6, the relevant question, that is the question. Assam shares interstate boundary on the eastern side with. So this
Arunachal Pradesh, Meghalaya and Tripura.
Manipur, Arunachal Pradesh, Meghalaya, Tripura. 4 questions was given.
So it shares this eastern side boundary with the Arunachal Pradesh as well as
Manipur. Now what they are saying is that if I get a mark there, I would have been selected. Now I have not been, this answer is not wrong. Now he's saying that there is no glaring defect, but my answer is also correct.
So everybody has attended that answer and as per they have given.
To that effect, others have
Both the
not.
answers are correct.
Yes.
Then if both the answers are correct, one of the question settler has taken one answer, what's wrong in that? How to, what is the problem in deciding that?
I have been deprived for because even in spite of giving me a right answer.
The persons who have given this choice of Manipur and already selected, they will also be deprived from that.
Lordship, then when I had approached and one seat was reserved for, one seat was kept reserved.
That doesn't
The
create any
learn-
right in favor of future.
As per my understanding, the
Then
learned
once-
single judge,
Once if the answer is to be changed, then the whole result is to be changed, not only your result. We can't do like this or order for this, that the only result of this person be.
This matter can be given to monitor. Since one of the answer. This question itself is wrong. In that case also, everybody will have to be given mark. But that doesn't raise the state.
Mr. Das, we can look at it from another angle. Manipur and Arunachal are both correct answers. That you agree. So therefore, the question is wrong. Options are wrong.
options.
Therefore,
The question will be
everybody,
wrong.
yes, everybody will get 1 mark. Not only your client, others will also get 1 mark. But that doesn't materially alter your client's standing. His
No,
merit
I got
position-
negative mark, Lord.
Sorry?
I got a negative mark.
You got a negative mark.
So that part, the 0.5 mark has been deducted from me.
It's a wrong question. Have you got those decisions? Supreme Court judgment which says if the question is wrong, 1 mark has to be given to everyone, or the question has to be
No.
eliminated from the.
So may I pray, in this case, I'm being led by Kane Chaudhary. Let him come, just pass over time. please.
After 2 weeks.
Item 26.
May I please, Your Lordship? My lord, today we are supposed to file the affidavit, but we are filing now, right now, my lord. Let the matter come up next week or after we do. Or filing today.
So you are paying any compensation or
Oh,
what?
yes. Compensation.
You are paying?
We are filing affidavit, we are filing today,
After a week?
my lord. I am deeply aware.
Item 27.
Yes, my lord, yesterday we filed affidavit, my lord.
Yeah.
Yesterday we filed affidavit, my lord. It is not in record, my lord. So may I pray this matter be fixed on 18th of April, my lord. And my lord, they filed amended OA, my lord, before the arms force development. It was not served to me also, my lord. Okay.
तो एफिडेविट के साथ लगा के मंडे को लगा
4 year sentence and that is.
Yes, my lord. Yes, my lord. Yes, my lord.
Entitled or suspension of sentences.
My lord, we filed yesterday affidavit, my lord. It is not record, my lord. And my lord,
Friday.
right?
Call that affidavit.
My lord, and another day, they filed an amended OML before the armed sports tribunal. It was not
Amended?
my lord, initially there's an order, my lord, on 19/2023, my lord, and that, my lord, is it was, my lord, not maintainable. Order was passed, my lord. OML.
Maintainable before?
No, this OA which was filed, my lord, it was not maintainable. That order is annexed, my lord, by the armed forces tribunal.
Not maintainable?
Yeah, because of this.
Where is that? Page?
Yes, my lord.
What maintainable car?
It was admitted, my lord. My page 427, my lord.
437.
427.
427, what it says.
They heard so-and-so learned counsel preparing applicant since admit since appeal has been prepared by attorney, it is not maintainable in law. They,
Since the appeal has been preferred by the attorney, it is not the convict is that directed to carry out message and the appeal may be heard. Legible copies of so and so supplied to the respondent.
yes, and that was filed.
Later of that date, the bench reassembles again. That is of 9/10. Then how the application has been filed, the remaining sentence in a ground? Then why they have decided if it was not maintainable? Why the appellate the Armed Force Tribunal has dismissed the
Yes,
application for suspension
Yes,
of
sir.
sentence on merit?
Yes, my lord. On the
Why? If it is not maintainable,
on the
then
it is also admit also right, my lord, they appeal. And they,
and if it was not maintainable, how they have admitted it?
yeah, that is there. So, my lord, this amended copy, yesterday they filed, my lord, amended, my lord.
Before the
Yes, madam, that is not,
get that.
not
That's the
start.
procedure
It
there.
was not annexed in this.
So far as regarding this suspension of sentence is concerned, it deserves to be suspended. Nothing else.
Well, on 18, I'll.
Tomorrow allow me the affidavit. Affidavit, whatever they call it.
Tomorrow.
Yes.
Yes.
Suspension of sentence of 4 years and he is in jail since long. No point in keeping it.
Supplementary list, item 40 for admission.
Happy, the Lordship. Lordship, we have requested for video conference. Lordship, we have requested for video conference, Senior Advocate Salman Khurshid, sir will appear.
Fine.
Well, Lords, I'm pleased, Your Lordship, I'm available now, let's to assist you.
May it please your lordship.
Yes.
And this is a writ appeal preferred by the state of Assam against the interim order passed on 27th of March 2024. The issue basically related to cancellation of a caste certificate granted in the year 2011. And in the writ petition, the main challenge of cancellation was not challenged also. Only the opinion was expressed and subsequently it was cancelled, but that cancellation was not challenged. I would like to take your lordship to the impugned judgment, which lordship will find at page 841. It starts from page 32. The judgment starts at page 34. 2-3 paragraphs of the judgments will be required because at paragraph 4, various facts were noted by the learned single judge.
The judgment is at page.
It starts from page 32.
Improved order is page.
Page 32, it starts. And the judgment starts at page 34. If lordship allows, I would like to place paragraph 4 and few paragraphs of the judgment. Page 35, paragraph 4. For the purpose of consideration of the interim prayer, the following necessary facts highlighted by the learned senior counsels for the parties are recorded. On 7/10/2011, the petitioner was issued a certificate certifying that the petitioner belongs to scheduled tribe claims, being member of Boro Kachari, lordship may note this, Boro Kachari community, recognized as scheduled tribe claims under the Constitution of India, Order 1950. Such certificate was issued by All Assam Tribal Sangha. The respondent number 8, Janaklal Bosumatari, challenged the election of the petitioner as member of parliament from a parliamentary constituency reserved for STP on the ground that petitioner does not belong to STP community. The petitioner number 8 had also filed a writ petition in the court in the year 2014 challenging such certificate. It is not correct, lordship, because the certificate was not challenged. The election petition was dismissed by this court and such decision was affirmed by the Honorable Apex Court. There was an election petition, lordship. The writ petition was closed being infructuous. Thereafter, the respondent number 8 filed a complaint before the chairman of SLAC on 11/6/2019 with a prayer to cancel the certificate.
Election petition was filed on the ground that.
He does not belong to that caste, but that certificate was never challenged. Therefore, the Supreme Court said
What happened in that election
that
petition?
because the certificate was valid at that point of time.
That petition was perhaps heard by me. That the petition.
Election petition was found, it was dismissed because the certificate was in force. And the Supreme Court also expressed that opinion. Supreme Court order already. Page 164, if Lordship is pleased to come there.
Something like that.
बहुत टाइम लगेगा
Yes.
If Lordship is pleased to come to page 169 for a moment, one paragraph from the Supreme Court judgment I would like to place before going further of the impugned judgment. Page 169, paragraph 7. That will clarify the situation.
169.
169.
Yes.
In a situation where there is no pleadings challenging the validity of the certificate certifying that the returned candidate to be a member of Boro Kachari community and therefore a scheduled tribe recognized under the presidential order, we cannot find any fault with the order of the High Court. Neither is there any pleadings nor issue framed with regard to the competence of the authority issuing the certificate to the act in the said manner, that is, to issue the certificate. When the election petitioner themselves did not challenge the validity of the certificate or the competence of the certificate issuing authority to issue the same, we do not see how the view taken by the High Court that the returned candidate belongs to Boro Kachari community can be faulted. We will therefore have no occasion to interfere with the order impugned in the present appeal. The appeal therefore has been to fail accordingly. So this order was passed on 31st of October 2018. Subsequently, the complaint was filed before the competent authority regarding the certificate. So that issue was never dealt with by the Honorable High Court as well as by the Honorable Supreme Court at any point of time. So I am coming back to page 35.
Yes.
Roman 3 now. On the basis of such a complaint, I'm reading paragraph 2, Roman 2. The respondent 8 Jonoklal Bosumatari challenged the election of the petitioner as member of parliament from a parliamentary constituency reserved for STP on the ground that petitioner does not belong to STP community. The respondent number 8 had also filed a writ petition in the court in the year 2014 challenging such certificate. The election petition was dismissed by this court and such decision was affirmed by the Honorable Apex Court. The writ petition was closed being infructuous. Thereafter, the respondent 8 filed a complaint before the chairman, SLAC, on 11 June 2019 with a prayer to cancel the certificate of 17th October 2011 issued in favor of the petitioner. On the basis of such a complaint, the Deputy Secretary to the Government of Assam, WPT and BC, requested the director to inquire about the caste status of the petitioner through vigilance inquiry. Then, Lordship, the inquiry things were written here, various notings. Now coming to what was the argument of the writ petitioner before the learned single judge, that is noted at paragraph 5, page 37. Basically, they have argued on 4 points. Mr. Salman Khurshid, learned senior counsel for the petitioner, argues the procedure that is required to be followed by caste scrutiny committee in terms of the determination made by the Honorable Apex Court in the case of Madhuri Patil, in as much as the procedure laid down in the office memorandum dated 11/5/2018, issued by the state of Assam, in terms of the decision rendered in Madhuri Patil Supra, has been totally flouted in as much as, without issuing any notice to the petitioner, a second enquiry was conducted. Whereas in the first vigilance enquiry, it was reported that the petitioner belongs to STP category. The petitioner was not even examined by the vigilance officer. The impugned order also lacks reasons. Therefore, on this count, the determination made against the petitioner is liable to be struck down. 2. The petitioner belongs to Boru Kachari community, and accordingly, the certificate was issued in favor of the petitioner in the year 2011, and same has not been doubted for being fraudulent or being issued by an incompetent authority. 3. The fundamental ground for rejection of caste status of the petitioner is based on the surnames used by the father of the petitioner and also by the petitioner, and thus the determination that Boru Kacharis do not use such surnames and therefore the petitioner does not belong to Boru Kachari community itself is based on no material and therefore perverse. There is also no determination that Boru Kacharis use certain surnames only, and that the status of Boru Kachari as tribal are determined on the basis of such surnames only. Such a course of action to doubt a caste certificate is not permissible under law. Therefore, the petitioner has been able to make out a prima facie case. And number 4, in view of the undisputed fact that the petitioner was issued a certificate by a competent authority, on the basis of which the petitioner was even elected as member of parliament twice from a reserved constituency reserved for STP candidates, and in view of the fact that the petitioner is enjoying the benefit of such caste certificate, the prima facie case as well as balance of convenience is in his favor. The petitioner is going to contest the parliamentary election once again from the reserved category constituency, and therefore in the event no interim order is passed, the petitioner will be deprived of such right, and in the event the petition is allowed, such deprivation cannot be compensated in terms of money. Accordingly, it is a fit case for grant of interim prayer. On the contrary, our argument was, Lordship, the vigilance officer, while dealing with the matter and inquiring into the matter, strictly followed not only the mandate of Madhuri Patil, but also the mandate of the office memorandum dated 11/5/2018. The vigilance officer had visited the places as required, personally verified and collected all the facts and social status, not only of the petitioner, but also of his mothers and siblings. The vigilance officer had also examined the school records of the petitioner, personally examined the siblings and mother of the petitioner. Gaunbura has also verified the peculiar anthropological traits, rituals, modes of marriage, etc. of the family of the petitioner, and therefore the state level scrutiny committee cannot be faulted with for relying on such report in as much as it is the mandate rendered in Madhuri Patil and provided in office memorandum dated 11/5/2018 that the SLC is to base its decision on the vigilance inquiry report. No second inquiry was conducted as urged by the learned senior counsel for the petitioner in as much as the inquiry was done by the same officer on the basis of same reference, and therefore report dated 23/10/2019 cannot be treated as final report not being prepared in terms of the OM dated 11/5/2018. The Vigilance Committee has every power to continue with the inquiry proceedings till the same is done in terms of the office memorandum, and in the case in hand, a bare perusal of the report dated 23/10/2019 shall reveal that the inquiry was not done in terms of the office memorandum, in as much as the said inquiry is confined to grant of certificate to Soronia Kochari people in terms of an office memorandum of 5/6/2018. Or once the claim of the petitioner that he belongs to Boru Kachari tribe was negated by the caste scrutiny committee, extension of such benefit by an interim order would be running contrary to the principles laid down in Madhuri Patil. Therefore, the balance of convenience is in not favor of the petitioner, when a cast scrutiny committee has already negated the claim of the petitioner to be a member of scheduled tribe community. In support of such contention, learned at so-and-so relied upon a particular case. The vigilance officer has strictly conducted his inquiry in terms of the extent, norms, and the decisions rendered in Madhuri Patil, and the petitioner had duly participated in the proceedings. The vigilance committee and the SLSC had duly adhered to the procedure prescribed, and therefore contention of the petitioner regarding the prima facie case is also liable to be rejected inasmuch as already a determination as prescribed under law has been made. 6. If the undue benefit is allowed to be enjoyed by the petitioner by virtue of an interim order, the same would rather cause irreparable loss and injury to the Boru Kachari community at large, inasmuch as the event the petitioner is elected as a member of parliament from a constituency reserved for STP, and the event that the writ petition is dismissed, the same will necessitate fresh election at the cost of state exchequer, and such loss cannot be compensated in terms of money, and therefore this is not a fit case where this court should exercise its discretionary power for granting interim order, inasmuch as pursuant to the impugned order, the caste certificate of the petitioner has already been cancelled, and such order of cancellation is not under challenge in the writ petition. In fact, we have made several other very important submissions which were not recorded. One is that the presidential order regarding the caste, that was argued very elaborately, that was not recorded. Also, we have said that there is no such prayer for challenging the cancellation of the certificate, that is not recorded, and various other judgments we have relied. All those were not recorded, but those are not considered also. Now coming to the findings.
At 2.
At 2.
We'll continue at 2. At 2. Yes. Yes.
Lordship. Page 40, Lordship. The findings of the learned single judge.
Fine.
Paragraph 7. The court has given anxious consideration to the submission advanced by the learned counsels for the parties and also perused the materials available on record. After inquiry, the vigilance officer concluded the petitioner does not belong to STP community. The inquiry officer reached his conclusion primarily on the following materials. The parents and grandparents of the petitioner use different surnames such as Sorukos, Das, Deka, Horu Das, which are not listed under Boru Kasari. Gambura stated that the family of the petitioner belongs to Coast community. Coast community belongs to OBC, Lordship, and became Soronia after taking religious Soron. NRC data says that they use the name Horukus, and land records shows they use the surname Horudas. Therefore, the parents of the petitioners were not Boru Kasaris, and interchange their surnames by the family is another cause of concern. An office memorandum dated 11/5/2018 was issued under the signature of the Commissioner and Secretary, WPT and BC Department, in pursuance of the decision of the Honorable Apex Court rendered in the case of Madhuri Patil, more particularly to create a vigilance cell at directorate level and also for the purpose of laying down modality and procedure dealing with the manner relating to fake certificate. It is mandated in Madhuri Patil as well as in the office memorandum of 2018. The scrutiny committee is to pass an appropriate order with brief reason in support thereof, after giving a reasonable opportunity of hearing, including an opportunity to lead evidence. Such a mandate, in the opinion of this court, is founded on the doctrine of odi alterim partem, which requires that the authority concerned must apply its mind and dispose of the matter by a reasoned and speaking order. A reason rationalizes an action. Such action can also be judged as well as grounded in reasons if there are reasons for performing the action. It can also be assessed if reasons are briefly recorded. In the case in hand, the impugned order clearly reveals that the SLEC has not given any reason for its determination not to say any brief reason in support of such order. This is the first finding that no reason was given. I'll come to that impugned order. There is no whisper of independent analysis, even brief as regard the finding of the inquiry committee, the contention raised by the petitioner and by the respondent. Number 8, no reasons not to say any brief reason has been recorded by the SLSC as regard its satisfaction to the finding of the inquiry report or the reasons of rejection of the contentions raised by the petitioner. Therefore, the impugned order is suggestive of an order which lacks a vital mandate of brief recording of reasons to be followed in terms of the apex count decision in Madhuri Patil and provided in OM dated 11/5/2018. This court also cannot be unmindful of the settled proposition of law that every state action must be supported by reason, more particularly when such an action, a valuable right already granted, is being taken away. I'm going to paragraph 13 now.
What about 12?
12, the procedure, let me read it, Lords. In Madhuri Patil, it is mandated because I'm going to place this judgment in full, the main portion. Anyway, let me read here also. Paragraph 13 and 13.5 and 13.6 are relevant of Madhuri Patil's case. In Madhuri Patil, it is mandated that the vigilance inspector would go to the local place of residence and original place of residence of the person concerned, and the said officer shall personally verify and collect all the facts of social status claimed by the candidate or his parents or guardians, as the case may be. It was mandated that he should examine the school records, birth registration, if any. He should also examine the parents, guardians, or the candidate, as the case may be, in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate, and then submit a report to the directorate together with all particulars as envisaged in the proforma, in particular relating to their peculiar anthropological traits, rituals, customs, mode of marriage, date ceremonies, method of burial of dead body, etc. Such procedure is also prescribed in paragraph 2 of the OM dated 11/5/2018. From the aforesaid, it is seen that an emphasis is being given both at paragraph 5 of Madhuri Patil as well as paragraph 2 of the OM, that the vigilance officer should examine the candidate or the parents or guardians in relation to their claim. Such prescription of personal examination of the parents, guardians of the candidate in the prima facie opinion of this court is made for the reason that the vigilance officer should also have access to the material under possession and the claim of the candidate or his parent guardians whose caste status is being inquired. Such inquiry shall in turn facilitate the SLSC to come to a just conclusion. In the case in hand, the report of the vigilance officer reveals that the father of the petitioner had already expired when the inquiry was conducted. However, the vigilance officer did not examine the petitioner personally, though he is a major person, and the inquiry relates to his tribal status in as much as in case of a minor examination of his parents, guardians shall be sufficient. It is seen from the report that there is no mention that the petitioner was personally examined by the vigilance officer or that the petitioner did not cooperate with the vigilance officer. Though it is recorded that the inquiry officer had personally examined the petitioner's mother, sister, Gaon Burak. It is also a prima facie opinion subject to final determination to be made. Under the scheme of scrutiny of caste, tribe status, the petitioner shall have a right to explain his case claim before the vigilance officer too, as such prescription shall give him an opportunity to place his claim during inquiry. However, as discussed herein above, his non-examination is suggestive of violation of such right. This was not mandated in the Supreme Court judgment. I'll come to that during my arguments. At paragraph 13.6 of Madhuri Patil, it was mandated that when a vigilance officer finds that the claim of social status is not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue so-cause notice supplying a copy of the report to the vigilance officer to the candidate, giving an opportunity to file reply and personal hearing. It is also mandated that an opportunity to adduce evidence may be given to the person concerned. After giving such opportunity, The committee is to make such inquiry as it deemed expedient and consider the claim vis-a-vis the objections raised by the candidate and passed an appropriate order with brief reason in support thereof. Similar provision is prescribed in paragraph 4 of the office memorandum. So this is a second, that deducing of evidence was one of the ground. Third, the so-cause notice issued to the petitioner reflects that it was intimated to the petitioner that he shall be given a chance of to personal hearing. However, in the notice, it was not intimated that the petitioner shall have a right to lay evidence personally or through an advocate as mandated in Madhuri Patil. It is true that the petitioner has not claimed in his so-called reply that he be given a chance to lead evidence in support of his contention. However, the fact also remains that it was not intimated to the petitioner that there is a scope of leading evidence in the proceedings to defend his social status. Such right is not only pivotal for a fair proceedings of determination of caste status under the mandate of Madhuri Patil and under the scheme of office memorandum, but also is a valuable right given to a person whose caste status is being determined, and such right in the prima facie view of this court cannot be lightly be taken away. Such course of action of non-intimation of right of the petitioner is also suggestive of vitiating the proceedings. Therefore, in the touchstone of the parameters laid down in Madhuri Patil and office memorandum dated 11/5/2018, this court is of the prima facie that the petitioner has been able to make out a case of procedural lapse and violation of the principle of natural justice. This was not their case at all. They did not have this kind of submissions. If Lordship immediately comes to paragraph 5 now, it will be easier. In paragraph 5, the learned single judge was pleased to record the submission of the senior counsel for the petitioners. First is that the procedure that is required to be followed in terms of the determination of Patil as well as OM issued by the state of the Madhuri Patil has totally been flouted, as much as without issuing any notice to the petition, a second inquiry was conducted. Whereas in the first vigilance inquiry, it was reported that the petitioner belongs to STP. The petitioner was not even examined by the vigilance officer, impugned, lacks reasons, etc. So I'll come to these reports a little bit later, but this is the first submission where there is no allegation of violation of natural justice. Number 2, ground, the petitioner belongs to Boru Kochari community and accordingly the certificate was issued by the competent authority. This is their second ground. Third, the fundamental ground for rejection of caste status of the petitioner is based on the surnames, regarding the various surnames used by their family tree. And fourth, the balance of convenience, because he has been already using this certificate for 8 years in 2 terms of the member of parliament. So these are the arguments they have made. But the learned single judge found here, paragraph 16, therefore in the touchstone of the parameters laid down in Madhuri Patil and office memorandum dated so and so, this court is of the prima facie view that the petitioner has been able to make out a case of procedural lapse and violation of principle of natural justice, which was never argued. So coming further, then there is a paragraph on caste certificate. A caste certificate is an acknowledgement to a person's belonging to a community which has faced years of oppression. Such a document is an essential document for scheduled persons. The petitioner was issued a certificate in the year 2011, and the complaint by the respondent was made in the year 2019. That is almost after 8 years after the certificate was issued. Proceedings of determination of caste certificate has been pending since the year 2019. In the meantime, the petitioner has been enjoying the benefit of such a certificate, and therefore, in view of the preliminary opinion formed and recorded above, the balance of convenience also tilts in favor of the petitioner in granting an interim order and not in favor of the state order, respondent number 8. Next, Lordship. It is true that the order of cancellation of the certificate is not under challenge. However, such cancellation is a consequential action, and therefore, when this court has formed an opinion to stay the impugned action, the natural corollary therefore is that all consequential action thereof shall also remain suspended. Coming to the judgment of the apex court in the case of Cotton so-and-so, relied by BC Das Learned Senior Counsel, this court is of the opinion that the ratio that no temporary injunction can be granted where no case for permanent injunction is made out, shall not help the respondents in view of the determination made herein above. Accordingly, it is provided that the impugned order dated so and so, and all consequential action thereof affecting the tribe status of the petitioner, including order of cancellation of such certificates, shall remain suspended till disposal of the writ petition. While parting of the record, it is made clear that the observations made herein are for the purpose of consideration of an interim order only, and the same shall not influence the final determination to be made in the writ petition. What is most surprising in this order? In this case, no notice was issued and there is no returnable date. This impugned order, this stay order has been granted. There has been no returnable date in this case now. This case may come after 5 years. As the petitioner is in the media saying that Honorable Court has stayed my case and now it will come after 5 years. So this is the first flaw in the interim order, that no notice in the writ petition has been issued till now. Final relief has been granted. It is in the nature of final relief. And the most important arguments which we place before the Honorable Court, that there is an order of this Honorable Court in 2014-15.
But all the respondents are represented through their.
We have filed affidavit, we have filed additional affidavit.
If all the respondents are represented through their consent, where was the question of issuing notices? You are in.
Then returnable date, Lordship, when the matter will come back again. Sure. I've ordered it for the Falcon.
That's not the main. These are technical issues. Yeah.
So there was no rule issued, no notice of motion issued, nothing. But that is on a technical side. Absolutely, but when I went through and I wanted to say when the matter is coming, then we could not find that matter is not coming. And when we heard that it will come after 5 years, definitely we have to look into it.
This order is in the IA or in the main writ petition?
In the main writ petition. Main writ petition. No IA was filed.
This order was passed on the first day.
The second day. Because I wanted 1 week's time to file affidavit. In the meantime, we filed 2 affidavits. In fact, the private respondent also filed or not, I am not sure. But we filed. And we filed a very important document on 12. Now I am coming to the impugned order. Impugned order was passed on 12th of January. They came sometime in the month of March, later part of March. And the impugned order was passed on 27th of March. So there is already a delay of more than 60 days. Let us go to the impugned order.
Where is the impugned order?
Yes. Impugned order is of
12th of January.
12th of January.
Yes.
And on 20th of January, the cancellation order was passed. They received the copy. A caveat was filed by the private respondent on 7th of February.
Which page is the order?
Yes.
Page
298.
158.
There are 2-3 places. No, we have also their writ petition also, it has been annexed. So I base the so-called.
This is
298.
298. Not here.
Annexure 27, 158.
Yes, Lordship.
This is what they read, sir. This is what they read. They have an example petitions.
In fact, it is in another page, but let us go to 298, Lordship. May I read it, Lordship? 12 January 2024. Whereas a presentation dated 11/6/2000 was submitted. These are all narration of the facts. Next page. Second paragraph. Whereas Sri Nobo Horonia petitioner, white petition dated 8/4/2020 and 18/6/2020 sought extension of time to submit his replies, and later he submitted his reply on 31st of August 2020 to the so-called notice to the Director of WPT and BC Department. Whereas Sri Jonaklal Bosumotari, he is the complainant, submitted his replies to the so-called notice issued by the Director on 21/9/2020. Whereas CID in the meantime submitted their second report number dated 4/3/2020. Whereas on receipt of the second report, CID Vigilance held a meeting on 14/9/2020 and decided to refer the case to State Level Scrutiny Committee by order dated 18/9/2020. Whereas hearing the State Level Scrutiny Committee was held on 11/11/2020, the committee heard Sri Nobo Kumar Horonia in person and perused his stand as reply dated 31/8/2020 to his so-called notice submitted to the Director of WPT and BC Department. Whereas hearing the State Level Committee was also held on 4/12/2020, wherein the committee heard Jonaklal Bosumotari in person. Jonaklal Bosumotari submitted another report on that day, which was being perused by the committee. Then an opinion was sought from us. We did not give any opinion. Now Lordship will kindly come to page 300, the second last paragraph. Whereas the SLSC examined in details the findings of the Vigilance Committee, which were stated as follows. The STP certificate was issued in the name of Nobokumar Horonia of Digholipar village as Boru Kachari on 12/10/2011, signed by Vice President All Assam Tribal Sangha, Tamulpur District Unit, was struck off, and Horukuch was written just above the name of another title. Horukuch was also given in bracket below the name of Sri Deepika. There is another entry in the name of Nobokumar Das Horonia, mother of as Srimati Deepika Das Horonia, wife of late Lokhi. Sorry, Lordship, there is a one page has been page 160. In this case, Lordship will kindly come to page 161. One page was missing here in this report.
You read this SL committee where as follows from one cell.
Yes. I'm reading again, Lordship, at page 160, the last paragraph. I'll read. The STP certificate was issued in the name of Nobokumar Horonia, son of so-and-so of Digholipar, as Boru Kachari on 12/10/2011, signed by Vice President All Assam Tribal Sangha, Tamulpur District Unit, and countersigned by SDO Civil, Tamulpur Subdivision on 19/10/2011. Records obtained during the course of inquiry reveals that parents and grandparents of Nobokumar Horonia, son of so-and-so, use surnames such as Horuku, Das, Deka, which are not listed as under Boru Kachari. Sri Dipanita Horonia, sister of Nobo Horonia, stated that she has STP certificate and she and her family belongs to Soronia community, and her father used to write Das as his title surname. Sri Nobokumar Horonia used the title Deka as recorded in the admission register of Tamulpur Government MV School in the year 1982. In the certificate of discharge or transfer to the reserve and recommendation of for civil employment dated 15 November 1980, issued by the commanding officer of Assam Regimental Center, Shillong, the class of late Lokhi Kanto Das, he is the father, son of Selaram Das, was written as Assamese and subclass as Das. Sri Roman Rabha, permanent government Gaubura of 4 villages, namely Ulubari village number 1, Jamuguri village and number 2 Jamuguri, and temporary Gaubura of 6 villages, namely Tamulpur, Sirangbari, East Hauli, Digholipar. 5 is Digholipar, the village of the petitioner. Stated that Sri Nobo Horonia was born in Digholipar village. His father name was late Lokhikanto Das, alias Horukoch. The name of Sri Nobo Kumar Horonia, grandfather, was late Selaram Das. Nobo Horonia's family actually belongs to Koch community, who became Horonia after taking religious Soron. One cannot change caste this by this means, Lordship, by taking preachings. Soron is preaching. He became devotee of some other tribe. That is not permissible. Even marriage is not a mode of change of caste.
What's new? What's the new? Grandparents of the surname does not belong to. It would be Boro Kacha. That Boro Kachari is the community. That's the argument of.
Even in his reply, he admitted that he has taken Soron and become Horonia. Horonia is never a tribal till now. A process is going on. There is an amendment bill of 2011 where Horonia Kosari was tried by the state of Assam to bring them under the realm of tribal people. Till now, it has not been. We have placed all these things and we have very strongly argued on those points. Horonia Kosari, which he claims to be, the central government did not give the clearance in 2011. Those amended bills are also part of the record. So, may I continue? Novo Horonia's family actually belongs to Coast community, that is OBC, not ST, who become Horonia after taking religious Horon. The NRC legacy data record shows that the title of Novo Kumar Horonia's father, late Lokhikanto, as Horu Coach. These are all OBC category. The land sitter registered the name of Sri Novo Kumar Horonia's father written as Lokhi Horukus, son of Sela Horukus, address Digholipar. In the land Jomabondi record, the name of Sri Novo Kumar Horonia's mother has been written as Srimati Deepika Das. Was struck off and Horukus was written just above the name. Another title, Horu Das, was also given in bracket below the name Srimati Deepika Das. There is another entry in the name of Novo Kumar Horonia's mother as Srimati Deepika Das Horonia, wife of Lokhi. According to HS certificate, father's name of Novo Kumar Horonia was recorded as Lokhi Kanto Horonia, which shows that the parents of Novo Kumar Horonia were not Boru Kacharis. Moreover, interchange of titles, surnames, that is Das, Horukus, Deka, Horonia, by Sri Novo Kumar Horonia and family is another cause of concern. Whereas SLEC committee, after careful perusal and examination of the written statements, documents, certificates submitted by Novo Kumar Horonia and Jonoklal Bosumate and the report submitted by the Vigilance Committee is of the view that Novo Kumar Horonia, son of late Lokhikanto Horonia alias late Lokhikanto Das alias Lokhikanto Horukucho village Digholipar, post office and PS Tamulpur district Baska, does not belong to the Boru/Boru Kochari community. While recording all these things, the main relevant portions from the reports and the statements were recorded by the committee. And therefore, when they came to the operative part, what they have said, whereas the SLEC committee, after careful perusal, they have not quoted in verbatim whatever is quoted above. If Lordship looks at the previous line, 10, ... where shows the parents of so-and-so. So everything has not been taken into consideration. The relevant portion which gives them and leads them to a particular conclusion, those were quoted. And finally, the committee says, whereas the SLSC committee, after careful perusal and examination of the written statements, documents, certificate, etc., submitted by Novo Kumar Horonia, Jonoklal Bosumate, and the report submitted by the Vigilance Committee is of the view that Novo Kumar Horonia, son of so-and-so, does not belong to Boru/Boru Kochari community. So the learned single judge obviously found that the reasoning was not proper. My submission is that we cannot expect from these executive persons a judgment written by these honorable court judges. There are a lot of Supreme Court judgments that in the operative part of a learned court's order cannot be equated with the administrative order.
Where is the impugn order?
Impugn order of the learned single judge.
Cancellation.
Cancellation order that in our additional affidavit we have brought. 307. And this was received by him on 13th of February, as well as the complainant filed a caveat on 7th of February. Till they filed the writ petition, they have not annexed it. And if Lordship is pleased to look at the prayer portion, there is no prayer for that. That Lordship will be 307. May I read it, Lordship? 28th January 2024. Whereas a representation dated 11/6/2019 was submitted to the state level scrutiny committee by Jonaklal for cancellation of STP certificate issued to Nobo Khoronia by the All Assam Tribal Sangha Tamulpur unit, countersigned by SDO Civil, dated 17/10/2011. Whereas the SLSC committee, after careful perusal and examination of the written statements, documents, certificates, etc., submitted by Nobo Kumar Khoronia and Jonaklal Bosumate and the report submitted by the Vigilance Committee, the SLSC issued speaking order dated 12/1/2024, stating that Nobo Kumar Khoronia, son of so-and-so, does not belong to Boru Kochari community. In view of above, the state level scrutiny. Move forward a little, yeah.
Page 307.
This is the cancellation.
Yes.
Move on to
Paid petition activity in the repetition.
Or High Court order. Yes,
Is on what page? Okay, do it.
So page number 87.
87.
Yes.
This is the order.
Yes.
Yes, Lord. Our first argument was that Khoronia Kosari is not covered by the presidential order, which Lordship will find at 260.
Which one? Which community?
Boru Kachari and Boru is covered. Khoronia Kachari.
Sarania Kachori.
Sarania Kachari. Their own admitted cases, they belong to Khoronia Kosari. All these vital documents and communications were not discussed in the impugned order. Page 62, 260, the Constitution Scheduled Tribes Order 1950, CO 22. This is issued under Article 342 of the Constitution of India. In exercise of the power conferred by Clause 1 of Article 342 of the Constitution, the President, after consultation with the governors and Raj Pramukhs of the state concerned, is pleased to make the following order, namely the order may be called Constitutional Scheduled Tribes Order 1950. Now Lordship will kindly come to page 262 for the state of Assam. It covers the pan-India, various states. For Assam, this is the relevant portion.
Sarania Kachari is not included.
He is not in the Boru and Boru Kachari are included. Now, what is the story of Boru Kachari? The state government is trying very hard to give Boru Kachari the status of the state government wants to give Sarania Kachari the status of tribal. Therefore, Lordship will kindly come to 276. Hmm? 275, the Constitution Scheduled Tribes Order, a Second Amendment Bill 2011. So this is at the stage of bill till now. It has not become an act, amended act. 291, Lordship will kindly come to a relevant portion here. For the state of Assam, serial number 8, Sarania Kachari. Have Lordship got it. Sarania Kachari, Lordship will kindly see the remark. Refer to the state government for further justification on the comments of RGI on 5/5/2006. So Assam government till now has not failed or have not been able to satisfy with the proper justification. That is the position. In 2013-14, the state government issued a notice, a communication to all the deputy commissioners that give all the Sarania Kacharis the tribal status certificate. Immediately a PL came before this honorable court, and that PL judgment I did like to place. Government had no other options to withdraw that. PIL 30/2019, Kalibari Educated Unemployed Youth Society, so and so, versus State of and Union of India. Here, Lordship will kindly come to paragraph 3. There are two parts of the challenge. The second challenge is regarding internal page 4 of page 7, fourth line from below of paragraph 3. The petitioner also assails the communication dated 5/6/2018 from the Commissioner and Secretary of the Government of Assam in the WPT and BC department made to all deputy commissioners and subdivisional officers in the state of Assam as regard issuing scheduled tribes plain certificate to Sarania Kachari's community as Kachari tribe in Assam. Then PIL came and we are on a sticky wicket, and therefore we have to withdraw it, paragraph 9. As regards the other notification dated 5/6/2018 by which the Commissioner and Secretary to the Government of Assam in the WPT and BC department had provided that all persons belonging to Sarania Kachari community will be issued STP certificate under the sub-tribe Kachari, the Secretary to the Government of Assam in the Tribal Affairs Department had made a statement before this court that the said communication in the meantime had also been withdrawn, and it will not have effects under the law any further, as the communication providing that Sarania Kachari community will also be issued STP certificate has been withdrawn. We are not required to adjudicate the matter any further. So we have withdrawn. And there is an order of the Honorable Court also. 245. Single judge order. Sorry, I'm 292, Lordship. The relevant portion at 296. It starts at 293, 95.
Yes.
My Lord Justice B.D. Agarwal judgment, 28/5/2014. Second last paragraph. I have also perused the list of scheduled tribes and incorporated in central order number 22. And prima facie, it appears to me that Poronia is not enlisted tribe, though the tribe certificate has been issued to respondent number 7. Accordingly, in the interim, it is ordered that the respondent number 5 and 6 shall not confine themselves to issue tribal certificates only to persons falling in the categories listed in the central order number 22. So this order was also passed by this honorable. Everything was placed before the learned single judge during the arguments.
Where is the order in the election petition? Is it annexed to the appeal?
Election
petition?
Election petitions order, the Supreme Court's order we have annexed.
No, the High Court's order?
High Court's order, no.
Okay.
Now, regarding the procedural lapse which the learned single judge found in our committee, let us go what exactly is stated in the Supreme Court judgment in Madhuri Patil, paragraph 35, 13.5 and 13.6. Whether any prejudice has been caused to the petitioner or not, whether there is any violation of the principle of natural justice or not, whether he wanted to adduce evidence or not, whether he was given full opportunity of his defense or not, Lord, that have to be now examined. He was given more than ample opportunities, and all effective opportunities was given to him. 1994-6, SCC page 241. Lordship will kindly come to paragraph 13. Various procedural things were recorded here. We are directly connected with 13.5 and 13.6.
Yes.
May I read it, Lord? 13.5. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate in the social status claims. The inspector would go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate, or the parents, or the guardians, as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parents, guardians, or the candidate. According to the learned single judge, that the vigilance officer should have examined the person concerned. But the Supreme Court says, or. So the option is there. But when his report comes and the concerned person is given ample opportunity to defend his case. But at the district level inquiry, that is not contemplated in the judgment itself. So the judgment says he should also examine the school record, but if any, he should also examine the parents, guardians, or the candidate. That option, it is not mandatory in nature. So or is there. That word or makes it very clear that it is not mandatory in nature, that we have to examine him at that stage. Because he has given the certificate. Now we have to verify whether the certificate was genuinely given or not. And we had no issue against him. There was complaint from his own community. Who is Jonaklal Bosumatari? He belongs to the scheduled tribe community.
Own community, you are claiming that he is not belonging to that community, and you are saying they complain by own community.
No. What I am...
His own community is Sarania Kacha.
Because when the complaint was lodged, he was holding a valid certificate. Today, I can say he does not belong to scheduled tribe plains. But when the complaint was lodged, both belong to the same community. On record, that is what the Supreme Court also said. The judgment of the Honorable Guwahati High Court was correct, because the validity of the certificate was not challenged. It was in force.
Yes.
He should also examine the parents, guardians, or the candidate in relation to their caste or such other persons. So a lot of options are there who have knowledge of the social status of the candidate and then submit a report to the directorate together with all particulars as envisaged in the proforma, in particular of the scheduled tribes relating to their peculiar anthropological, ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc. by the caste or tribes or tribal communities concerned. So this is the role of the vigilance officer, what he can do. Thereafter, the role of the SL, SC comes. The director concerned on receipt of the report from the vigilance officer, if he found the claim for social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue so-cause notice supplying a copy of the report of the vigilance officer to the candidate by a registered post with acknowledgement due or through the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of receipt of the notice and in no case on request not more than 30 days from the date of the receipt of the notice. But here they are about a lapse of 7-8 months, and we are not against that because at that time it was the peak season of COVID-1. In case the candidate seeks an opportunity of hearing and claims an inquiry to be made in that behalf, the director on receipt of such representation reply shall convene the committee and the joint/additional secretary as chairman who shall give reasonable opportunity to the candidate, parents, guardians to adduce all evidence in support of their claim. According to the learned single judge, we have not given him the opportunity to adduce evidence. I'll place from record. He was given all opportunities. He wanted to submit 2 replies. 2 replies were taken into consideration. He wanted personal hearing. Personal hearing was allowed. He wanted advocate. Advocate was accompanying him all across.
Yes.
From records, Lordship, there is no case that that opportunity was denied to him. Who shall give reasonable opportunity to the candidate, parents, guardians to adduce all evidence in support of their claim. A public notice by beat of drum or any other convenient mode may be published in the village or locality, and if any person or association opposes such a claim, an opportunity to adduce evidence may be given to him it. After giving such opportunity either in person or through counsel, the committee may make such inquiry as it deems expedient and consider the claims vis-a-vis the objection raised by the candidate or opponent and pass appropriate order with brief reasons in support thereof. So this is basically the procedure. And once everything is completed, Lordship, then under the notification as well as here also if it goes against him, the certificate as well as the certificate should be immediately cancelled and also it should be confiscated. Yes, number 9. The inquiry should be completed as expeditiously as possible, preferably by day-to-day proceedings within such period not exceeding 2 months. If after inquiry the caste scrutiny committee finds the claim to be false or spurious, they should pass an order cancelling the certificate issued and confiscate the same. So on 12th, the opinion was expressed, and on 28th of January, it was cancelled. Whether it was confiscated or not, I have no knowledge. It should communicate within 1 month from the date of the conclusion of the proceedings, the results of inquiry to the parents, guardians, or the applicant. So it was sent to him. An email was sent to him on 13th of February in his official address of the parliament. The other side, the complainant filed a caveat on 7th of February annexing the cancellation order. An MP, it is expected that he will take the order and challenge it. But if your Lordship is pleased to look at his prayer now. What was his prayer in the writ petition? Page 87. first prayer is that to set aside and quash the impugned order dated 6/6/2019, constituting a vigilance cell in the Director of WPT and BC Department in violation of Direction 5 of paragraph 13 of Madhuri Patil. So initially, our committee consisted of 6 members. So they had some objection, and also there is an absence of one research officer. So when our affidavit came with all the credentials of all the persons, then they did not argue this. So this prayer is basically not argued before the learned single judge regarding constitution of the committee. 2, to quash and set aside the impugned communication dated 11/7/2019 issued by the Deputy Secretary requesting for inquiry into the social status of the petitioner having no authority. So this also was not argued at all. Third, to quash and set aside the impugned notification 5/9/2022 reconstituting the state level committee being issued in violation of direction paragraph 4 of para 13 of the Madhuri Patil. This was also abandoned during the hearing because initially when the first committee was constituted, there were 2 directorates of the tribal affairs. It was amalgamated, so 6 members committee became 5 members committee, so it was reconstituted. So they have not argued all these 3 points. Fourth, to quash and set aside the impugned speaking order dated 12/1/2024 of the state level committee being nullified the perverse violation of the direction of Madhuri Patil's case. So this was their argument. And after the return of the rule, which was not issued till now, hearing of the parties further pleased to make the rule absolute, etc. And in the interim, pending disposal of the writ petition, the Honorable Court would be pleased to stay the operation of the impugned order dated 12/1/2024 and any consequential order. This was the interim prayer. The final prayer did not have the prayer to set aside any consequential order. And this writ petition was filed on 4th of March, page 90. Already it was more than 30, 10, about 40 days, 45 days have elapsed. And there was no submission from their side that they did not receive the 28th January's cancellation order. So if they do not want to challenge it, had it been any common person, I would have understood. But he is a lawmaker of the country at the highest level. It is expected by any normal prudence that he should challenge the ultimate cancellation. If suppose Lordship set aside 12/1/2024, 21/2024 will still remain. And if it was confiscated, what benefit we will get? He could, when we have submitted the additional affidavit by annexing the document, I was expecting they will pray for amending the writ petition. That was also not done. We are fair, Lordship. It is not that for that benefit, if he belongs to scheduled tribe Lordship, there is no occasion to state to object it. But if he does not belong, it is our constitutional duty of the state government to protect the interest of the genuine tribal people. So now, although the learned single judge did not deliberate upon 2 reports, what are these 2 reports? They have argued, the first argument is that 2 reports, second report was given without giving them a notice. What were these 3 reports? Let us go to that, Lordship. 248. So when the vigilance cell was constituted, on page 103, for a second, Lordship. The complaint came, then the vigilance cell was constituted, that is at page 103. Complaint is at page 98. Let us go chronologically, Lordship. Page 98 is the complaint of Janaklal Bosumutari. 11/6/2019. I'm just reiterating in 2018, 31st October, the Supreme Court delivered the judgment in the election petition that there was no challenge to the certificate.
The judgment is of
31st October 2018. So thereafter, this gentleman, Jonaklal Bosumotari Lordship, he lodged a complaint on 11 June 2019. So subsequent action. To the Chairman, State Level Scrutiny Committee for cancellation of STP certificate issued to Nobakumar Foronia by All Assam Tribal Sangha, dated 17/6/2011.
Yes.
Main thrust is at number 2. That, sir, under Article 242(1) of the Constitution of India, the President, after Constitution consultation, it should be consultation with the Governor of the said state by public notification, specify the tribes and tribal communities and part or group within tribes or tribal community to be ST. Under for Article 242 of the Constitution, the Parliament made by law include or exclude the list of STs specified in the notification issued under Clause 1, any tribal or tribal community or part thereof. Here, he quoted.
the complaint by him.
Yes, the complaint, because the complaint main thrust is on that presidential circular. He has quoted also that Boru Kosari is only eligible to become in the page 100 and serial number 5.
Mr. Sekia, you sum up your arguments now.
What are
you sum up your arguments now?
My sum up, because I have to place the facts, then only I can sum up, Lordship. Facts are not yet placed because the learned single just said there's a procedural lapse. So what procedural lapse we have done? And our main plank of arguments were not touched also. In fact, the final opinion has been expressed. In fact, if the case was disposed of, I would have been more happy instead of an
Therefore, one of your submission is that apart from the technical issues which you pointed out, one of the argument is that by the interim order, the writ petition has been finally decided or final relief has been granted.
Absolutely.
Without taking note of the plea raised by the respondents. That's one of the arguments.
That is one of the arguments.
Yes.
And
What is the
why I am
second?
saying this,
Yes.
why I am placing this. Number 5. I have placed 4 very important judgments of the Supreme Court, where there is no way to tinker with the language, words, letters of the presidential order.
Right.
Those judgments I have cited. I argued the case for 4 or 5 hours.
Those are not reflected in the order.
Not at all.
All right. Then what is the next point?
Because that is why if I place the facts, then those judgments will become relevant. Otherwise, those judgments, if I say the judgments without placing the facts, then it will not
That's
have
right.
no meaning.
This is settled law.
This is settled law.
Presidential order cannot
Absolutely.
be tinkered.
Then that is why how a prima facie case has been made out. Their own admitted cases there belong to Saronia Kosari.
No,
What? Saronia Kosari.
sorry, my lords, I'm sorry I have to intervene. That is not our admitted case. This is the second time my learned friend is
I am
said so.
speaking from the replies. Their
Well,
replies.
We'll hear you. Mr.
What I am submitting, everything is on record from the documents I am
Please let him
speaking.
complete. Then we'll give you a chance. Yes.
Huh? And his sister also said we belong to Saronia community. I have placed that already.
So, all right. The third point is Saronia Kosari is what they are claiming, which is not included in the presidential order.
Absolutely.
So, therefore, even if it is accepted that he is a Saronia Kosari, even then he is not.
Where in the reply?
Yes. Where is the reply of the writ petitioner?
Yes. Reply of the petitioner is that there are 2 replies. 2 enquiry reports at 109 and 121 and so cause notice 127. Reply is at 134. There are 2 replies.
Yes.
134. when we issued the so-called notice, Lordship, then he wrote to us on twice that he wants some legible documents and he wants some the reports. Everything was furnished to him. And finally, he gave the first reply on 31st August, page 134. And what he was asking us here, because the learned single said that we did not give him opportunity. Here, before first second paragraph, before I proceed to reply to the aforesaid so-called notice, beg to state that the reference letter dated 11/3/2020, this is a so-called notice, addressed to me, was delivered by the postal peon on 3/4/2020 at my addressee residence, which was acknowledged by my younger brother. But due to lockdown called by the government of India, midnight so-and-so, I confined in Nalbari, etc. I'm skipping all these things. Now, coming to the last part of that, page 135, middle part. Therefore, after receipt of the documents, I am submitting my reply to the so-called notice within stipulated time after receipt of the documents. And I would also prefer for personal hearing after submission of reply. This is his first request, that he wants personal hearing. And after stating all these things, again, at page 148, that this is my reply to the so-called notice dated 11/3/2020. I may be permitted to submit additional reply if so required to clarify my stand. I would also prefer the personal hearing after submission of the reply. So he wanted additional reply, we gave him. He wanted personal hearing, we gave him. He did not mention about advocate. Advocate was all along present with him. That also Lordship will see. And his own submission about Horon in his reply at page 144.
No, what we are asking you, has he claimed himself to be Boro Kasari or Khoronia Kasari?
If that question is put to them, it will be better, because his claim is his own submission here that he was Horonia and he took Horon. That he has stated. 144.
Yes, read.
144D. That the allegation against me are totally misconceived and misleading. It is stoutly denied that Horonia is a distinct and separate community. It is a part of Boro Kochari community. It may be also stated that taking of Saran under Mahapurush Srimanta Shankardev or following the tenets of Guru, Deva, Namas, Bhakat, ipso facto would not disqualify me from enjoying the status of scheduled tribe. What was their submission, if I remember correctly? That I belong to Horonia Kosari and Horonia Kosari belongs to Boro Kochari.
No.
This is their submission. And it is indicated in paragraph D that I have taken Saran. So whether by taking Saran, one can change his tribe or culture, it is not permissible. Even if I marry a tribal woman, Lordship, I will not become a tribal, or vice versa. By marriage also, one cannot change their caste. Otherwise, everybody will change. This will be a mockery. All these reservations and all these presidential orders will go haywire if this is permitted. E. All people with Sorania in their surname have their ethnic roots either in Boro Kochari community or Rabha community. Likewise, person with surname Modahi are originally from Rabha community. As per government notification, a scheduled tribe person does not lose his scheduled tribe status due to change of his religion. It will also be pertinent to mention herein that Koch community has been practicing Hinduism since the immemorial time, and as such, the contention of the complainant of Soronia or the persons with the surnames Koru Koch are part of Koch community is without any basis. So what I am trying to emphasize is that for Soronia Kochari, the government is well versed with that thing, and therefore that amendment bill was tried to be brought into 2011. All these research works are going on, and government issued a notification to all the deputy commissioners that issue certificate to Soronia Kocharis as tribals. Then the PIL came up. Then government had to withdraw because government cannot tinker with the
Where is the
president.
second reply?
Second reply. 151. Yes, additional reply. That was dated little bit later, 21st of December, 2020.
Yes.
Here, the last line of page 151, as I have also preferred for personal hearing and to file additional reply if required. This was his earlier statement. That the Director of Welfare and Plain Tribe, etc., circulated a letter on 7/11/2020, calling from the state level scrutiny committee meeting held on 11/11/2020 for caste verification of me and another. The copy of the aforesaid letter was also communicated to me. Accordingly, I, along with my learned advocates, appeared before the state level scrutiny committee on 11/11/2022 at 11 a.m. in the D block of 3rd floor Janata Bhavan. During the course of submission made by my learned advocates before the scrutiny committee, it was brought to the notice of us that another complaint has been filed by Janoklal Bosumde before the chairman. So all this thing. So what I am trying to emphasize is that he came before the committee for personal hearing. His advocate was there. Where is the denial of opportunity of adducing evidence? Whatever they asked us, we gave. If they wanted to examine a single person, that opportunity would have been given, but that request, the list of witnesses must be given by him. And he is not a layman, and he is accompanied by advocate, well armed. So that violation of the principles of natural justice, in my humble submission, is prima facie, Lordship, a manifest error has been committed. Madhuri Patil says within 30 days reply must come. His reply came after 7-8 months. Then additional came after another 2 months. First reply came on 31st of August. Second reply came on 21st of December. And lucky him that from 2020 till 2024 January, the matter was in cold storage. I do not know what happened there, but this is a serious affair because Madhuri Patil also says that there should be day-to-day hearing and immediately the order should be given.
So what happened in this case?
4 years, Lordship, that nobody is challenging. Otherwise, we'll have to take some action. If Lordship gives some observation, we'll be more than happy.
I think here it's autonomous. This is under BTC.
It is under state government.
State government.
State government. State government is at fault. I admit, I do not have any shame to say that. If Lordship gives some observation that why 4 years time was taken to deliver this order, whatever order, this way, that way. Because Madhuri Patil have to be followed in letter and spirit. That challenge they have not made. That because the benefit was been enjoying.
Yes.
Residential. Now the vigilance officers report. The first report and the second report.
Yes.
Because lot of stress has been given on the first report by them.
Fine.
Page 248. 109, Lord Civil Candidacy, 109.
109.
109. I am reading it from their repetitions document, but it was annexed with our affidavit in opposition also.
Yes.
23rd of October, Lordship will kindly take note of this date because the so-called notice was issued subsequently, much later. So 23rd October 2019, the enquiry officer, the same person, the Joduram Malakar, he wrote to the superintendent of police. The vigilance committee entrusted this gentleman, Joduram Kakoti, to do the enquiry. Joduram Malakar. Serial number 2, down below, Lordship, four lines from below. For verification of the caste certificate of Nobo Horonia, MP Kokrajhar, son of so-and-so of Tamulpur, Baska, I visited the given address, examined the person noted and other prominent persons of that locality and found that the said persons belong to Horonia Kosari community, not Boruk Kosari, which is under the purview of STP category. Why? Because at that point of time, that notification of the state government was in force. It was not withdrawn. It was issued in 2018, and this report was of 2019, which was not correctly done by the state government. So immediately when the PIL came, it was...
When it was withdrawn?
It was withdrawn sometime in the PIL. I'll just give the date. The date is there. Because there is a reference in this report itself.
Order made.
In the meantime, it has been. Date is not given. In the meantime, it has been withdrawn. That is the statement. But there is a reference of it, Lordship. If I am allowed to go a little bit ahead.
So this means Saranya Kachari is definitely not treated as a part of the dimension.
Yes.
Yes. So, and found that said person belongs to Horonia Kosari community, which is under the purview of STP category. In this regard, I collected the copy of the letter issued by Government of Assam, Department of Welfare of Plain Tribes and Backward Classes, Dispur, Guwahati, by letter dated 15 June 2018, addressed to all Deputy Commissioners of District of Assam and all SDO civils of Assam, directing to issue STP certificates to Horonia Kosari community as Kosari tribes in Assam. For ready reference, I am enclosing the photocopy of the caste certificate along with the government letter as ready reference, which is annexes Annexer B. This was the preliminary first round he has done, and he was submitted, and it was stated below. In course of inquiry, it is found that the complaint lodged by civilian, namely Fatima Khanum, these are respect of others, Jonoklal Bosumatar in case of the petitioner, is not genuine. So his whole reliance of the first report was basically on the state government's notification of 15 June 2018. Then the Vigilance Committee look into it and asked him to go for further inquiry on the basis of the parameters laid in Madhuri Patil's case. That report, Lordship will find at page 121. The detailed report now.
When the inquiry, this vigilance, the cell has directed him to conduct a detailed inquiry.
The detailed inquiry regarding ancestors, caste status, legacy data verification, land documents, admission report, etc.
Where is that?
That page 121.
That's the report. No?
This is the report. But where this committee has asked the inspector.
Here it is reflected here, Lordship. If I allow to read the first paragraph itself.
Yes.
In inviting a reference to the subject cited above and in continuations. So this is not a second report. It is a continuation of the previous report submitted on the matter. I have the honor to submit a report on the complaint submitted by Jonoklal Bosumatari of village so-and-so, which was endorsed to me for inquiry. As directed, the inquiry was conducted taking into consideration the below mentioned points along with those mentioned in the office memorandum of 11th May 2018 of the WPT and BC department, because the first report did not consider all these aspects. So now that memorandum, which I'll also place little bit later, Lordship, have all the parameters as indicated and mentioned in the Madhuri Patil's case. Ancestors, caste certificate, legacy data verification, land documents, admission report, etc. So a very detailed report, Lordship. If Lordship wants me to go through it, then I can read it out also. The complainant steps taken during inquiry. The complainant Sri Jonaklal Bosumatari of village so-and-so was examined at CID headquarters, in which he produced a written statement duly signed by him, which is enclosed as Annexure A. The complainant stated that all Assam Tribal Sangha, being an NGO, is no competent authority to issue caste certificate, and that Nobokumar Khoronia has obtained STP by claiming to be Boru Kochari, suppressing the fact that the community to which he belongs, that is Soronia Kosari Khoronia community, is not entitled in the constitutional ST order 1950, as amended from time to time under Article 342. The complainant further stated that Khoronia people adopted non-tribal Assamese caste Hindu surnames like Das, Deka, Hoikia, Khoronia, etc., with general caste Assamese language, culture, customs, tradition, festival, dress, religious beliefs, worship place, Namghar, etc., which are distinctly different from Boru Kacharis, who have their own sets of tribal surnames and own language, culture, customs, festival, rituals, ceremonies, dress code, religious beliefs, open worship place known as Garja Sthali, Khela Sthali, folk songs, folk dance, etc. The Boru Kacharis have their own closely knitted clan-based surnames peculiar to the community and are related to nature, such as Bosumatari, earth folk, Narjari, jute folk, Doimari, water folk, Islari, god folk, etc. Thus, Nobo Kumar Khoronia cannot claim that he belongs to Boru Kochari, as his surname is Soronia, which is not a Boru Kochari surname, the complainant stated. Then, serial number 4. I have visited the native place of Nobo Kumar Khoronia located at Digholi village. Srimati Deepika Das, mother of Nobo Khoronia, wife of so-and-so, Dipanita Khoronia, sister of Nobo Khoronia.
Just a minute, this report,
Yes.
you have already referred or
The relevant portions are quoted in the impugned order.
which improved order?
12/1/2024.
This report of the vigilance officer you have supplied.
Yes.
Where is that?
He asks for it, Lordship. His first paragraph in his reply. The reply to Kulwa. The committee. I have placed it. The first paragraph, he has said everything. Enquiry report, his reply. Page 134.
Yes.
He had given a very detailed reply, Lordship.
The reply to be going to issue to me by reference.
In the first paragraph itself.
Submit an explanation. That's it. Hey,
It may be-
read this.
Here, Lordship, it may be mentioned that along last 3 lines.
Is Annexure 18 is what? This is the notice issued to him?
Notice was issued. It was enclosed with him. I'll place that later also. The communication, page 132. 132.
Enquiry report.
132, if Lordship is pleased to look.
Yes.
In place, enclosure copy of vigilant officers' report, statements, and other documents. 35/2020. Then he said some of the documents are not legible.
Page 134, last line.
Yes, last 2 lines he has stated also. Then some pages were not legible. He wanted fresh copies. We gave fresh copies also. That is also admitted. There is no answer regarding presidential order first submission, Lord. Absolutely no. They want to say that Soronia Kosari belongs to Boru Kochari. That submission, in my humble submission, is not accepted because of the various Supreme Court judgments where very clearly said that any authority cannot. Second.
Yes.
So Mr. Saikia, what my lord is indicating that we have understood the thrust of your argument. You have taken us through the
The main
details, but the fact remains that this way, that way, we are not going to decide that. If at all, it is the learned single judge who has to decide it. We will only see whether this order, the interim order, which is an absolute interim order, was justified in the facts of the
Exactly.
case.
Whether
or
a
not.
prima facie case has been made out.
That's the only
my
point.
argument. That's
That's
why
the
I'm
only
not taking your lordships to the various facets of the inquiry
Correct.
and the reply.
So we have noted your submissions broadly.
Main judgments I'd like to place, lordship. It can be done tomorrow morning, lordship.
No, what tomorrow morning? Today you completed.
Yes, no difficult.
Tomorrow morning again, we are not going to.
The other side counsel is also in the.
Other side counsel is here.
You have to
He
hear
will
him.
also make his submissions and will, he said it will not post it for further hearing.
No
Because
difficulty.
tomorrow also again.
No, I am ready, lordship. I'm ready from since morning, lordship. Yes. So the second report, lordship, will kindly see page 121.
Yes.
So on four aspects, 4 areas, the inquiry was conducted.
Yes.
Ancestor, these are all as per the norms set in Madhuri Patel's paragraph 13(5). What is the role and in which area the inquiry is to be made? The learned single just said that we have not, the inquiry officer, the vigilance officer did not examine the petitioner or the person concerned. That, in my humble submission, is not contemplated in the Madhuri Patel's paragraph 13.
You said or means.
Or is there.
Person, he has a choice or he can do that.
Yes. Then I visited the paragraph, visited native places, then Gaon, his own sister, his school.
He recorded extensively.
As
That
details.
report he has, though in the final report, some of the portion of these findings have been recorded, but this vigilance officer report is also speaking about, also speaks about something else also.
Yes, lordship. Now, the finding of the vigilance officer at page 124, 2 paragraphs there.
Yes.
From the copy of the official letter forwarded to the secretary to the government of Assam, dated 21st April 2014 by SDO Civil, it has been found that the concerned officer had stated till receipt of direction from the authorities in this regard, the process of countersigning Horonia people shown as Rabha Boro Kochari is kept in abeyance. There was earlier another order also that don't issue to other people except Boro Kocharis. Then 4, serial number 4. In this order dated WPC so-and-so, 28/4/2014, the Honorable Guwahati High Court has observed that Horonia is not enlisted tribe in the list of scheduled tribes incorporated in Central Order number 22, though the tribe certificate has been issued to Nobokumar Horonia. Further, the Honorable High Court has also ordered that the All Assam Tribal Sangha to issue tribal certificate only to those persons falling in the categories listed in Central Order 2020.
That writ petition has been decided. That writ petition of 2000.
It was withdrawn.
No, if this comes.
It was withdrawn.
Yes.
Because of the subsequent development of the PIL, because the division bench allowed it to be withdrawn.
So in the morning we have to see.
When the PIL came with the PIL order, I have placed this morning, Lord, in the beginning.
That writ petition was listed along with that PIL. No.
Then page 1 next page, at 11. In the certificate issued by the commanding officer of Assam Regimental Center, Shillong, certificate of discharge and transfer and reserve of the so-and-so, 15th November 1980, the name of Sri Nobo Kumar Phoronia's father was written as Nayak Lokhikanto Das, son of so-and-so, and his class was written as Assamese and subclass as Das. From the above facts, it can be found that Nobo Kumar Phoronia and his family were using titles Das, Deka, which do not fall under the category of Boru Kochari. The findings. One finding is, Lordship, that he belongs to Phoronia Kochari. Second finding is that he does not belong to Boru Kochari. And his sister at serial number 8, Sri Dipannita Phoronia, sister of Nobo Kumar Phoronia, stated that she is working in a beauty parlor and had stopped studying after passing PU from Tamulpur HS school. She further stated that she has STP certificate and that she and her family belong to Phoronia community, and the father used to write Das as title. So sister also admit they belong to Phoronia community. Then page 126, after 15. From the above given points which were collected during the course of enquiry, it can be seen that the process of countersigning Phoronia people shown as Rabha or Boru Kochari has been kept in abeyance by the concerned SDO Civil and Sri Binita Pegu, Deputy Secretary to the Government of Assam WPT and BC Department, in her affidavit submitted to the Honorable Guwahati High Court on 26/5/2015 had stated that Phoronia Kochari had not been enlisted in the ST list of Assam as per the Scheduled Caste and Scheduled Tribe order as amended from time to time. Moreover, Sri Srinivasan so-and-so, by order dated 22nd March 1977, had cautioned against issuing certificates without proper verification. Observing that Phoronia is not enlisted tribe in the list of scheduled tribes incorporated in Central Order 22, though tribe certificate had been issued to Nobo Kumar Phoronia, the Honorable Guwahati High Court in WPC so-and-so ordered all Assam Tribal Congo to issue tribal certificate only to those persons falling in the categories listed in Central Order. And last page 128, the third finding, though STP certificate was issued in the name of Nobo Kumar Phoronia, son of so-and-so of village so-and-so, as Boru Kochari on 12/10/2011 by the Vice President All Assam Tribal Congo Tamulpur District Unit and countersigned by SDO Civil Tamulpur on 19/10/2011, record obtained during the course of enquiry revealed that the parents and grandparents of Nobo Kumar Phoronia, late so-and-so, use titles such as Porukuch, Deka, Das, which are not listed under the Boru Kochari. Further, Nobo Kumar Phoronia used the title Deka as recorded in the admission register of Tamulpur Government MV School in the year 1982.
That have already been recorded.
Yes. And then one was even the NRC record of 1951 also says they belong to Horukuch. Page 126, 13 and 14. NRC legacy data says Horukuch. And 14, the land records. So he has done a very extensive investigation and enquiry. And thereafter, the so-cause notice, Lordship will see the first report was of the first report which was placed 2019, and second report was of February 2020. It was signed on 4/2/2020. So two reports amalgamated together, and thereafter the so-cause notice was issued on 11th March 2020. So there is no question of part report. When a composite enquiry was done, then the so-cause notice was issued by giving all documents, whatever is required to him. Page 131, along with the so-cause notice also, enclosure copy of the vigilant officer's report. So that report was given along with the so-cause. And thereafter, he wanted some additional time. Lordship will see that page 132, 38 May 2020, it was written by the director to Nobo Kumar Phoronia, request serial number 2 reference, request for time extension by later dated 8/4/2020. So he was given However, your request for copies of statement and documents have been accepted, and therefore thereby copies of the documents are attached with this letter. Then last line, your request for personal hearing shall be considered only after receipt of your detailed explanation. Then next page, 12/8/2020, he wanted some legible documents. I am to inform you that your request for extension of time to reply of so-cause notice has been accepted, and you are given last opportunity to submit reply to the so-cause notice dated so and so.
We have gone through that. We have now come to the judgment part.
Judgment part.
You are right.
Two 2001, 1 SCC, page 4.
2001.
1 SCC, page 4. State of Maharashtra versus Milind and others, paragraph 15.
She's not.
Okay.
In relation to what?
General principles laid down regarding interpretation of the presidential orders. The learned single judge in my case has not touched that aspect, that area, although it was elaborately argued, and that was my opening argument actually. And in our affidavit, we have annexed everything. Thus, it is clear that the states have no power to amend presidential orders. So what we have done in 2018 was wrong. Thus, it is clear that the state have no power to amend presidential order. Consequently, a party in power or the government of the day in a state is from the pressure or burden of tinkering with the presidential orders, either to gain popularity or secure votes. Number of persons in order to gain advantage in securing admission in educational institution and employment in state services have been claiming as belonging to either scheduled caste or scheduled tribe, depriving genuine and needy persons belonging to scheduled caste and scheduled tribes covered by the presidential order, defeating and frustrating to a large extent the very object of protective discrimination given to such people based on their educational and social backwardness. Court cannot and should not expand jurisdiction to deal with the question as to whether a particular caste, subcaste, a group, or part of tribe, subtribe is included in any of the entries mentioned in the presidential order issued under Article 341 and 342. Particularly so when in clause 2 of the said article, it is expressly stated that the said orders cannot be amended or varied except by law made by Parliament. The power to include or exclude, amend or alter presidential order is expressly and exclusively conferred on and vested with Parliament, and that too by making a law in that regard. The President had the benefit of consulting the state through governors of the state, which had the means and machinery to find out and recommend as to whether
This para number 15 is can't change the amend the presidential order without there being any law made by the parliament.
Absolutely, Lordship. So when he belongs to Soronia Kosari,
Yes.
nobody can say that he belongs to Boru Kochari.
Fine.
Paragraph 28 for a moment.
The very same judgment.
And paragraph 28, yes, yes. Yes. 28. Be it respectful agreement, we reaffirm the ratio of the two constitutional bench judgments, sub-bench aforementioned, and state in clear terms that no inquiry at all is permissible and no evidence can be let in to find out and decide that if any tribe or tribal community or part or group they are within any entry concerned in the president. So there is no scope of bringing sub-tribes into that category. That also is not permissible. Oh dear. Same case, in paragraph 36, Lordship, one line. In the light of what is stated above, the following propositions emerge. It is not at all permissible to hold any inquiry or let in any evidence to decide or declare that any tribe or tribal community or part or group within any tribe or tribal community is included in the general
Mr. Advocate General, it is in relation to inclusion of a
Yes.
community in the tribe.
Yes,
or
here,
tribal.
what that is precisely happening here.
But here the question is whether the certificate issued in favor of that this respondent or the petitioner before the learned single judge was genuine or not.
And that aspect is one aspect. The other aspect which they are trying to argue that Saranya Kochari is also a part of Boru Kochari. That is their argument.
That is not. That is even though if that argument is there, that can't be accepted, sir.
And if that
That
is
can't
falling
be
from
accepted
Lordship,
that the
I can stop
Saranya
right now.
Kachari community
Yes, Lordship. If that is
doesn't find place in the presidential
absolutely,
order,
Lordship,
it
that
can't
is
be.
our case. But when they wanted to say that Saranya Kochari belongs to Boru Kochari.
So far as regarding the order of the learned single judge is concerned, it is not reflected that that is their argument. That Saranya Kachari is also a tribe, and therefore the certificate
Yes,
is
Lordship.
genuine.
Now let me stop. Lordship will
They are
hear the other
claiming-
side. What is
they are
their stand?
They are claiming that I belong to Boru Kachari community.
Their argument.
Despite being, I am mentioning my surname as Sarania or whatever it may be, but I belong to that community and therefore this certificate is genuine. This was not their case.
That is why they gave lot of importance and stretch on the first report where the vigilance officer said they belong to Saranya Kochari.
That's
If that is the case, to counter those arguments, because their case is that the first report is in our favor, although these were not deliberated in the order, therefore we belong to Boru Kachari. That is let me stop now, Lordship. Lordship will hear them. Then, if required, I'll give reply.
Yes. Yes.
Well, Lords, if your Lordship will permit me, I'm grateful. Lords, your Lordships have had a long afternoon. Well, Lords, I'm trying to make it as precise and as specific as possible.
It is a specific request to you also.
Grateful. Well, Lords, I'll certainly do that. Well, Lords, your Lordships will permit me and my learned friend will forgive me for this. Your Lordships asked two very specific questions. Your Lordship said, where have they conceded that they are Saranya Kachari?
Mr. Khurshed, your voice is little low.
You're not audible.
You're
My
not-
Lord, I'm sorry. I will increase the. Is that a little better, my lords? I've just increased.
That's right. Now it's okay.
Grateful, my lords, grateful. So, my lords, your lordship's question was, where have they conceded? My learned friend said, admittedly, they have said they are Saranya Kachari. My lords, my certificate says Boro Kachari. But I have clearly said that those Boros who take Saran are also called Saranyas. That's all. I cannot and I don't want to go into the issue of whether you can add to the list of the presidential order or you cannot add. That the law is very clear. My claim is on the basis of Boro Kachari, and my learned friend should have left it at that. Saranya is a surname that is used or a title that is used by those Boros who have taken Saran. That is very clear, and it was very clear to the learned single judge as well. My lords, the second point that I might say is that, my lords, as far as the two reports are concerned, I was not successful in pressing the first report. My lords, the learned judge very clearly said that the first report doesn't help you entirely. My lords, that may be so. That's not an issue.
Right, because the first report was only on the basis of a
Of that,
order
which
of the government which has later been withdrawn.
quite right. My lord, so what I would submit is that is neither here nor there. The reliance on a notification that has been withdrawn is neither here nor there, because my certificate goes back to 2011. There was no notification at that time.
Yes.
I was given that certificate, but be that as it may, let us accept for arguments that the first report was a report that has a deficiency and had a flaw. My learned friend says that the second report is actually a continuation, although my learned friend repeatedly said, and when the order was passed for cancellation, whereas this first report says this, whereas the second report says this, be that as it may. My lords, let's take the second report. The issue again was another question that your lordships asked. Where is the letter indicating that go and report further, go and investigate further. Where is that report? Where is that letter? There is no such letter. Have they taken it upon themselves that they would continue to investigate, etc., etc.? My lords, these are interesting questions that will arise finally when this matter is heard. But my lords,
Mr. Khurshid, though in a second report, he has referred to a letter of the year 2019, certainly that letter is not there. But since you yourself are admitting that this first report is neither here and not there, then the vigilance officer is required to submit a detailed report regarding the complaint filed by the person.
right, my lords, I'm only saying this because when I showed to your lordships the paragraphs that your lordships have already read in Madhuri Patil requires that in case you reject a report, then there would be a notice and so on and so forth. I'm only saying from the purpose of natural justice that my learned friend was trying to get away from. But my lords, there is another question. So this was this question your lordships asked, where is that letter? Where was the mandate given, etc., etc. And that didn't come. My lords, then one important question is there were many arguments that were made. Indeed, what the learned single judge has done is to say that you've only recited and repeated what the report said. You haven't analyzed it. And if your lordships will recall that order, that impugned order that came before the single judge, my lords, that simply repeats, we went this is what so-and-so said, we went this, so-and-so said, so-and-so said. There's no analysis. And for the purposes of analysis, adducing evidence was necessary. My lords, that comes directly from Madhuri Patil, adducing evidence. Now, to say that you didn't ask for adducing evidence, therefore we didn't let you adduce evidence would be extremely unfair. This is the government, the state government acting upon a citizen. And to say that we trip you up because you didn't ask for adducing evidence. My lords, the evidence would have been necessary to cross-examine people who are being quoted as having said that I am not a Boro Kachari, to cross-examine them, to show how important they are, to show how influential they are, etc., etc. My lords, I can go into much details. Beating of the...
Mr. Khurshid,
my lords.
The vigilance officer's report was supplied to you, wherein these details that he has examined those persons and he has inquired into this office.
Quite right.
In your reply, where you have mentioned that these, I want to cross-examine those persons or I want to adduce the evidence, where is that, sir? Without even whispering a word, how can you expect the respondents that they'll issue a notice to adduce you the evidence?
Well, Lords, may I answer that? Well, Lords, they said if you want a personal appearance, we'll give you a personal appearance.
Fine.
But they don't say that personal appearance and adducing of evidence. If you want, we will let you adduce evidence. Well, Lords, this is the unconscionable relationship. When somebody who has had a valid certificate for such a long time is to be...
In your reply,
my lords,
Chairman state level, this page number, annexure 24, page number 151.
My lords.
In the page number 155 precisely.
My lords.
In last para, you said, I am grateful to the respected chairman and the members of the state level caste scrutiny committee for giving me a patient hearing for the cause of justice. The hearing was provided to you. Who prevented you to ask them to that I want to adduce some evidence? Give me some opportunity.
Well,
you have written in that I want to produce some more documents. They granted you time.
They granted me time, and I accept that I was heard, etc. I was granted time. But should not they have warned? I ask myself, should they not have warned me that look, if you wanted to adduce evidence, we will give you an opportunity to adduce evidence. But to wait for me,
Mr. It's not a case of a layman. It's a member of parliament twice.
It may be so. It's an MP, but your lordship knows MPs don't always are well versed in law.
Article 20 doesn't come. There's no question of silence or anything.
So, the issue was that there should have been an analysis and a speaking order.
Supposed to give evidence against you also. It's a civil proceeding. Yes.
My lords, I'm sorry, your lordship is asking me something.
No, just we are asking that in your reply, two replies, there is no whisper about that. Please grant me opportunity to adduce evidence.
I agree, my lords. There, I will have to.
Personal hearing you asked for and they have given you the personal hearing.
I'll have to urge your lordships to consider that when somebody is being put in such a tight position, it's only fair to share with that person that these are the rights that you have. My lords, even when somebody is being arrested, his rights are read out to him, and he's told that these are the rights. You have a right to stay quiet. My lords, now
that is the requirement of the law, sir.
Quite right.
This is a civil proceeding.
My lords, this is a civil
proceeding.
Well, this is a civil proceedings, but therefore the onus would lie only of balance of probabilities. But the fact is that the civil proceedings with far-reaching consequences, be that as it may, Lord, may I just lastly say, be that as it may, my lords, these are situations in which the honorable single judge has come to a conclusion that the balance of convenience and the interest lies in my favor. And then the argument given is that if I am allowed to keep my status for contesting this election, that election will have to be set aside in case I lose in my writ petition. As your lordships have said, all that has to be done. But simply because there will be another election, when elections are set aside, my lords, there are fresh elections. When something illegal is found.
That can't be a matter of concern.
So, my lords, it can't be. I'm grateful, my lords. That can't be a matter of concern. But, my lords, the important point that remains here is, in the present circumstances, would there be balance of convenience? And, my lords, in fairness, let me just say this to your lordships. It's also been pointed out that I didn't even raise the issue of natural justice. My lords, natural justice is inbuilt as far as Madhuri Patil is concerned. And I said that there's a violation of Madhuri Patil. May not have gone into specifics. It doesn't lie in the mouth of my learned friend to say that his arguments were not recorded and then to say that Mr. Khurshid didn't argue this. Not fair. Well, it's not fair to the honorable judge. It's not fair to the court that whatever is found to be relevant at that time is recorded. No thesis is being written that everything will be put, but the relevant portions are recorded, and on the relevant portions, if a conclusion can be drawn, then that conclusion is drawn. My lords, that's only fair. Now, I make it very clear, my lords, as far as I am concerned, never have I said that I'm Saranya and therefore I'm a tribal. I've said I'm a Boro Kachari, but with a Saranya surname, and therefore I'm a tribal. What have my sisters said? What has my family said? Again, those are very important factors, but those have not been analyzed. What exactly did my sister say? It's being assumed that she said that she was Saranya. My lords, because we are seen as a Saranya community, we call ourselves Saranya. But when we come to establishing our tribal status, then we have to say we are Boro Kachari. Otherwise, in 2011, why would I have said I'm a Boro Kachari and taken a Boro Kachari certificate? Well, there's one important point. My learned friend, I don't know how my learned friend said no notice has been issued, because the notice was dispensed. We were all there. The next date is 19th of April. He's talking about 5 years. 19th of April is the next date. It was an interim order. It's another matter that by 19th of April, my lords, the election process will proceed. But if I lose this election process, simply because I don't get protection, having had this certificate for over 10 years, my lords, it will be grossly unfair. It will be grossly.
Mr. Khurshid, you have to answer two queries of the court.
My lords, of course.
First is that this order passed by the learned single judge amounts to giving you final relief.
My lords.
First is this, and another is, what is your date of birth? The date of birth of the petitioner.
Of the petitioner, my lords, your lordships are asking me a question that I have not briefed on.
Yeah, but it has to be 53 years. In the affidavit,
53 years, it is around 53 years.
My lords.
one thing is bothering us, that why you have this obtained this certificate in the year 2011 only? Why you have not obtained this certificate since your birth, or after while at the time of admission in school, or any other? at the
Well,
time-
as your lordship knows, I assume that your lordships are familiar with this, is even the sister said that I didn't take a certificate. The mother said I didn't take a certificate because I didn't need it. At that time, we didn't need it. Now we are taking it. Well, people have become conscious of this certificate with the reservation policies and with admission reservations, etc. That's why people are seeking. The reason is, my lords, as your lordships asked me this very, very important question. Madhuri Patil is also of 1994. Why did the Supreme Court not think of Madhuri Patil before 1994? Well, it's because there was an increasing level of demand for certificates, and therefore those demands. Well, I have a question. I have an issue which relates to the actual formation, the constitution of the Vigilance Committee and the constitutional. But I hadn't argued this because when we were when we were arguing the interim relief at that stage, my learned friend had categorically said, we are not bringing out everything today because this is only on interim relief. So we concentrated on interim relief. Arguments didn't go on for 4 hours. Arguments did go on for some time, but we concentrated on interim relief because the election process has kicked in. And if we don't have interim relief, then in 10 days' time, we will be out of the election campaign completely. That's the reason why we were pressing on this. And my lords, nothing is lost to anybody. Nothing is lost to anybody if finally the writ petition is decided against me and I have to be unseated. I will have to be unseated. But before that happens, I will have an ability to produce everything. Maybe, my lords, your lordships may finally come to a conclusion, and the single judge may do this.
Yes.
Well, it's possible that the honorable single judge will come to the conclusion that this matter needs to be remanded back so that there is a fresh round of inquiry. And after that, whatever happens, whatever is concluded, subject to whatever the High Court finally decides, that this matter can be disposed of in one way or another. At least we will not be left feeling that because of circumstances where they have emerged, we've been denied an opportunity to be able to put our case across. Your lordships have right. Your lordships have said you should have been better advised. My lords, maybe if my learned friend, my client had reached out to me earlier, perhaps I would have advised that why don't you insist on adducing evidence, etc., etc.
Mr. Khurshid, sorry to interrupt. Why no challenge to the decree?
Well, your lordship is saying to the cancellation.
Yes, yes.
Cancellation. Well, the cancellation, we didn't move on cancellation for two reasons. Because although my learned friend has said that we were informed, we were not actually informed. That is my instruction. And we would have moved an amendment, which is the natural thing to do, is to move an amendment. But we would have lost this very critical point during amendment and also replies filed in amendment, etc. The matter may not have been taken up. Your lordship were just told that this matter has not been listed for disposal. And I've just seen the order in which this matter was listed for disposal on 19th of April. It was only that the interim order was reserved, and the interim order was then passed subsequently. So when the interim order was passed, there was no issue about the date on which the main matter will be heard. Your lordships may instruct that the matter be heard on an urgent basis. Your lordships, either in the as a position in Chief Justice, my lords, on the administrative side, or sitting in a division bench, your lordships can direct that this matter should be disposed of in public interest as quickly as possible. There's no reason why that can't be done. But today, my lords, I would urge you, it is important that
What about their arguments regarding grant of final relief at the stage of?
Well, lords, that I must answer. That I must answer. Well, lords, that argument can be used for any blocking off anything at all. This is not final relief, because the final relief will come only when the writ is decided, and the writ may be decided against me, so it can't be final relief. I am not saying that that becomes infructuous by my getting. So, my lords, if there was a law which said if you're elected for 5 years once, maybe that is what will happen in one election, one nation, etc. That once you're elected for 5 years, you can't be unseated for 5 years, whatever may be the reason. Then it would have been final relief given at an interim stage. But this is not final relief. This is at interim stage. I can now position myself to be an MP, but I will cease to be an MP when the final relief is finally decided by the honorable single judge. So, my lords, that argument is only to be stated, to be rejected entirely. So, my lords, I do believe one can go into much detail about what has been placed. But, my lords, clearly, as far as the report, so-called second report is concerned, that second report has just been accepted by the committee, without any analysis, without any judgment on this is right, this must be correct, this must be correct. And that's happened because there's been no evidence adduced, my lords. That's why the committee was obviously his hands were tied. My lords, there are at least 2 or 3 judgments. If your lordships will permit, those judgments are available with my colleague in the court.
Yes.
My lords, we can give those judgments because those judgments indicate clearly how finality in these matters should be preferred. And my lords, particularly the Maharashtra Adivasi Thakur Jamaat. But in all fairness, I will tell you, my lords, that those states have now also set up their rules in these matters. The rules are pari materia with what the general law is as far as the law is concerned. My lords, paragraph in this. Paragraph 36, my lords. My learned friend has the copies of this. If your lordship will see paragraph 36A. Well, may I just read it out to you? Well, this is an honorable bench of 3 judges, my lords. Paragraph 36A, and I will urge your lordships to give cognizance to this, my lords, despite the fact that there are rules in Maharashtra.
Yes.
If I may just read that, my lords. 36A, only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant, the case can be referred to Vigilance Cell. While referring the case to Vigilance Cell, the scrutiny committee must record brief reasons for coming to the conclusion that it is not satisfied with the material produced by the applicant. Only after the case is referred to the Vigilance Cell for making inquiry, an occasion for conduct of affinity test will arise. My lords, affinity test, as your lordships know, is a fairly detailed exercise. It's not so casually done as it seems to have been done by the visiting investigating officer. So, my lords, this is a clear indication as to how seriously the matter is to be taken, and only then to proceed to the prejudice of any citizen who's likely to lose his certificate. So, my lords, this is one judgment. And the other judgment, my lords, if I may just ask my friend to place the other judgment before your lordships. There's only one paragraph there, my lords. That's J. Chitra. That's 2021 9 SCC 811. This is J. Chitra versus District Collector and Chairman of State Level Vigilance Committee. And in this, my lords, if your lordships will be good enough to look at paragraph 10. Well, this is about reopening the matter. If your lordships are persuaded that this has really been a reopening of the matter of the first report, but then I am conscious that I've conceded before your lordships that there was a misreading by the vigilance officer about the notification of the state government. I've conceded that before your lordship, so I
Yes.
wouldn't put too much emphasis on that. But the emphasis here on giving finality to reports is very important. And therefore, reopening of anything is to be
Yes.
taken with a certain amount of serious scrutiny. And what I want to submit to your lordships is that this is the reopening of a certificate of 2011 where there is no allegation of fraud or misrepresentation. There's no allegation of fraud or misrepresentation. Therefore, the reopening should also have reasons given as to why it is important that this should be.
Mr. Kochi, in
My lord.
fact, the certificate was issued in the year 2011, whereas this respondent number 8 has questioned that certificate in the year 2014 itself.
Well, it's in
There
2004.
is a writ petition wherein the
Well,
notices issued
your
but
lordship
ultimately
is-
that writ petition was dismissed as withdrawn. In that writ petition, your notice, your caste certificate was also under challenge.
Well, they did, but as your lordship see that they didn't pursue this to a conclusion. 2014. It's only once again in 2019 that they question it. They thought that they could do it by a circular.
After this 2014, he has challenged your election also on the very
That's-
same ground.
Well, 2014 matter was disposed of in 2023. Therefore, he was hoping just to stick to that. Then, after the election petitions were dismissed,
2018, 19.
well, his complaint is of 2019.
14 का था, 18 में judgment.
So, well,
Yeah.
so let's only to say that that the diligence that he might have shown, he
You're
hasn't.
referring to this J. Chitra judgment, which para you're referring to?
Well, it's paragraph 10. Well, it's paragraph 10. It's about finality of a decision. But I may once again concede before your lordship that I said that the first report has some flaws. The first report has some flaws.
Neither here nor there.
So, my lord, those are my words. Your lordships have taken my words very seriously. But the fact remains, my lords, I have to be fair.
What's your argument?
Well, I have to be fair to the bench. But there were other findings there as well. He went and examined the organization that had granted the certificate. There were even questions raised about that organization's right to grant the certificates, but that's never in the law been questioned. Those are then, my lords, just last of all, my lords, if I may just request your lordships to read Madhuri Patil, paragraph 7. But my lords, if your lordship would see it in sequence of 5, 7, and 6, if your lordships permit. So paragraph 13 is where this is provided. And in paragraph 13, your lordships will see there is 4 is about the setting of the committee of 3 officers. Well, as I haven't taken your lordships to save your lordships time about 3 officers and 5 officers. There are issues there. But if your lordships will see 5,
yes,
the constitution of vigilance cell consisting of senior deputy superintendent of police in overall charge and number of police inspectors to investigate into the social status claims, etc. Well, this is paragraph 5. And after paragraph 5, and then, my lords, there is a very clear, if your lordship will see the last 6 lines, he should also examine the parent, guardian, and the candidate in relation to their caste, etc., or such other person who have knowledge of the social status, and then submit. My lords, the submission made to your lordship was that you can go to the guardian or to the person concerned. Now, if there is no guardian, and if there are no siblings, then where do you go? So to read or so lightly, my lords, I think is not permissible. And then the report is to be submitted to the director, my lords. If your lordship will go directly from this to paragraph 7, from 5 to paragraph 7, in case the report is in favor of the candidate, and found to be genuine and true, no further action can be taken except where the report or the particulars given are procured or found to be false or fraudulently obtained, and in the latter event, the same procedure as is envisaged in paragraph 6 to be followed. So, my lords, subject to the concession that I've made to your lordships, that is the treatment to be given. And in any case, the departure from a report that is supposed to be favorable, departure from that report can only be by a speaking order, and obviously a notice to be given to the person concerned. Well, lords, every time the status is interfered with, or there is a question mark on the status of the proceedings, notice must be given. That's part of natural justice. Well, lords, I still submit to your lordships that the adducing of evidence is not something that should come from my requesting or asking for it, but it should be part of the natural process of providing natural justice. Well, lords, if I may submit that. I'm grateful to your lordships for a patient hearing. Well, lords, I promise your lordships that it would be very brief, and I hope that I can get an accommodation for making it as brief as possible.
Certainly, no doubt, no doubt. Sir. Thank you.
I'm grateful, my lords, I'm grateful.
Regarding two queries, lordship. One is that whether any direction was given for him to do the inquiry. There's a reference of letter dated 30/7/2019.
Yeah.
In the inquiry report, second inquiry report, the detailed inquiry report.
Where is that letter?
That letter is at page 106.
What first report is?
106.
Yes, lordship. An expert aim about its
Letter from the director WPTBC. Is the letter to the
next page, lordship will find the date. The original copy is at page 108, which is not legible, so type copy at 106.
37/2000.
Well, lords, your lordship may please see the date of this letter.
This
And
date is
also-
of 30th/7/2019.
19, my lords, and the first report is 23rd of October 2019.
And also,
First
lordship,
report,
and the
first report
nomination of
In fact, in the first report, would be subject to correction. The first report was submitted by him on 2019.
Yes, lordship.
Which is that date?
my lord, 23rd of October 2019.
October 2019, wherein he has made he has given a reference to a letter dated 24/6/2019.
Well, it's because that 26,
Just 24/6/2019, and in the second report, he has given reference to the
letter of 30.
letter of 30th of July
July.
2019.
And 24/6, that letter, lordship will find at page 104.
Letter after submission of this report to the committee.
104. One is from the director, one is from his department, the police department, CID department. Office of the Additional Director of Police, CID Assam. Nomination of officers, Jodu Malakar. The first one of page 104 is a general one, and the second one is the specific one. Here, Jonoklal Bosumatar's complaint was taken into consideration. Page 107 at serial number 2, that is the reference.
The first was
First was a general. Nomination of office, in inviting reference, the following DSPs and inspectors are nominated for vigilance cell as member from CID Assam to deal with matters relating to fake caste certificates. So a panel was constituted by CID. General. Then next, that 37/2019, here Jodu Malakar was entrusted for investigating 3 cases: Fatima Khatun complainant, Janaklal Bosumutari complainant, and Karishma Sardar. So serial number 2 is related to our present litigation.
Yes.
And regarding the information given to him, this is the email.
Information regarding what?
Cancellation certificate. 13th February, within 30 days, we have to communicate. So it was, the order was issued on 28th of January and it was given on 13th of February to his official address. Official mail.
Yes. That's not his. That's all. You want to refer some, any other authorities or what, or it's okay?
Authority, 2, 3 others on similar lines. I can give lordship for
similar-
reference only. Yes, DT.
On which point?
On the point that, on the same point regarding the importance of the constitutional orders.
So that is there. That constitutional bench judgment is already there, and
Yes,
the
Lord.
other part, other is also not disputing the said proposition of law.
Yes, Lord.
That is there. There is no question.
One judgment, Lordship, 2021, 9 SCC.
Yes.
2021, volume 9 SCC, page.
What is it for?
This is Chandrabahan versus State of Maharashtra.
For?
Here some additional caste, they wanted the benefit of tribe. And the Supreme Court says, once the claim of the appellant that he belonged to Halba stood negated by the caste scrutiny committee, no advantage can be thereafter be extended to the appellant. Any such extension would be running counter to the legislation as well as the authoritative pronouncement of Jagdish Balram Bahira. Paragraph 10 and 11. So here Saranya Kachari, he is given the benefit of Boru Kachari lordship. That will be an extension of the benefit, which is not permissible as on date.
Fine.
Right side. I think this.
Deeply obliged, lordship.
Deeply obliged, Maharaj.
Okay, we'll dictate the order.
No, they went.
He has come.
Lordship,